Good morning. The meeting will now come to order. Welcome to this meeting of the Charlotte Unified Development Board of Adjustment on Tuesday, September 30th, 2025. My name is Deborah Dryden, and I am Chair of the Board. Would the board members please go around and state your name for the record? Mr. Williamson?
Marshall Williamson. Kevin Shea.
Amy Son.
Hamilton Court.
Thank you very much. Also present are Solomon Fortune, our zoning administrator, John Kinley, the senior project manager, Crystal Monsegur, our planner, Kamisha Lampley, the clerk to the board, Teree Hegler Gray, senior assistant city attorney and advisor to the planning staff, Jill Sanchez Myers, senior assistant city attorney, advisor to the board, Paige Inman, assistant city attorney, advisor to the board, and Garrison Thomas, our Veritex court reporter. Each of today's hearings is a quasi-judicial evidentiary hearing. That means it is like a court hearing. State law sets specific procedures and rules concerning how this board must make its decisions. These rules are different from other types of land use decisions like rezoning cases. The board's discretion is limited. The board must base its decisions upon competent, relevant, and substantial evidence in the record. A quasi-judicial decision is not a popularity contest. It is a decision constrained by the standards in the ordinance and based on the facts presented. If you will be speaking as a witness, please focus on the facts and ordinance standards, not personal preference or opinion. General witness testimony is limited to facts. For certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts of increased traffic. Individuals providing expert opinion must be qualified as experts and provide the factual evidence upon which they base their expert opinion. While hearsay evidence is not specifically excluded, it is only given limited weight. Parties with standing have rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, the city, and individuals who can show they will suffer specific damages or special damages. Other individuals may provide testimony as witnesses when recognized by the board. Witnesses must swear or affirm their testimony. Any individual wishing to speak as a witness today was required to sign up. If you haven't done so, please do so now. The parties to each case are entitled to an impartial decision maker. A board member may not participate in a hearing if they have a fixed opinion about the matter, a financial interest in the outcome of the matter, or a close familial, business, or associational relationship with an affected person. The parties to each case also have a right for any ex parte communication to be disclosed. Ex parte communication is any communication about the case outside of the hearing. That may include site visits as well as conversations with parties or the general public. At the start of each case, any potential conflict of interest or ex parte communication should be disclosed by a board member if applicable. These matters may also be raised by an affected party. Today's meeting will follow the order printed on the agenda. The order of the regular agenda will be as follows. All parties who plan to give testimony must be sworn in. A city staff member will present a summary of the case. The board may question the staff member, and then the applicant may question the staff member. The applicant presents their testimony for the case, and any sworn witnesses provide testimony. The board and city staff may question the applicant and their witnesses. Other parties wishing to speak for or against a case will be given reasonable time to present sworn testimony. The staff and then the applicant will be given an opportunity for rebuttal. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations after hearing each case. The chairperson calls for a motion and a second to approve or deny the variance or the appeal. In the case of an appeal, the chairperson calls for a motion and a second to uphold, modify, or reverse the administrator's decision. The decision will be made by a simple majority vote of the board. However, the board may elect to take up to 30 days to render the decision. You may remain present during the deliberations, or you may call the zoning staff after the session to receive the decision of the board. If you wish to receive a written copy of the decision letter, please indicate so on the sign in sheet. All exhibits must remain with the board. If your case is not appealed to Superior Court after 30 days, you may pick them up or they will be destroyed. Appeal from this board is to the Mecklenburg County Superior Court. You have 30 days from the date of the board's written decision in which to appeal, in accordance with NCGS 160D-405D. At this time, I will, let's see. The oath of office for the staff, if you would please stand. Thank you. Do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth? Thank you very much. We now open the evidentiary hearing for variance number 2025-00036. The property is located at 3656 DeWitt Lane. Before we begin, does any board member have a conflict of interest or potential conflict or any ex parte communication they need to disclose? All right.
I do have two corrections for the agenda. Well, it's additions really. So it's two addresses and two parcel numbers for this property.
Okay.
It's 3656 DeWitt Lane and 3653 DeWitt Lane. And then the other parcel number is 14901-251. And that is reflected on the findings of facts that Kamisha just passed out to you.
Okay. Thank you. Two parcels. Okay. All right.
Okay, this is a variance request, case 2025-00036 by Dream Key Partners, represented by the Green Team of Design Resource Group for property that's located at 3656 and 3653 DeWitt Lane for those two parcels, and they're owned by the city of Charlotte. And they're seeking a variance from the legacy zoning ordinance, which in that section that's referenced there, I'm not going to read all that out, but to allow only screen fencing for backflow preventers. The ordinance requires that you screen the backflow preventers with either a 5-foot wide planting strip or a combination of a 3-foot wide planting strip and some sort of screen fence or wall. The variance would be with a condition that the plantings shown on the approved plan or approved land development plans be provided nearby to the backflow preventers as shown on the variance plan exhibit. And I'll show you what that is as we go through the presentation. So here's a vicinity map of the property. This is located down towards South Tryon and where South Tryon and 77 come together off of South Boulevard and directly on DeWitt Lane. The property has undergone development, and this is an aerial map. It's a little bit out of date and doesn't show the buildings on the property as they are today, but you can see the other development that's been occurring in the area. Zoning map, it's a zone TOD-CC, Transit Oriented Development Community Center. That zoning district has been updated to translated to match the UDO. However, this development came in prior to the UDO's implementation, so they were reviewed under the, I think, 2019 legacy zoning ordinance. Yeah, January 22, 2019 legacy zoning ordinance. Here's a bird's eye view of the property on exhibit 4, just showing where they had started construction. And again, it's both parcels on either side of DeWitt Lane. And the variance request again is to allow the only screening for the backflow preventers to be a fence.
Go back. Where's the backflow? Where are we talking about?
So roughly where the stars are, but I'll show you a site plan that shows
All
in
right,
more
thank you.
detail. So here's the section from the 2019 zoning ordinance that requires that utility structures be screened with a 5-foot wide planting strip that consists of evergreen shrubbery or as an option, a fence may be used in lieu of it. But if you do the fence down in number 2, it says that you need to have an additional 3-foot wide planting strip in addition to the screen fence. So these are approved land development plans, and the project number on exhibit number 7, it was that stands for Housing Trust Fund 2020-00001 was their plan that went through review. And this is just some multiple sheets. They've got, the first one is the site plan sheet, second one is from the utility plan, and the last one is from the planting plan. And you can see I've circled on here both sides of the streets, the area where the backflow preventers are located. It's hard to tell, but there are little gray boxes there and there and there, and then there and there and there, there and there and there on all 3 sheets. And you can see that they had intended or planned on having these landscape shrubs. That's what the little circles are around each of those boxes. So the intent was, according to the planting plan, to provide the planting strip. There was no indication of providing any sort of screen wall. So they should have been set back 5 feet from the back of sidewalk. But when you measure these distances on these plans, it's actually 2.3 feet. So they got approved plans with the only 2.3 feet of separation. That's ultimately what got constructed, as you can see here and here. So there's no room basically to install the required planting strip and screening without relocating these backflow preventers. And they are pretty much construction completed. They're waiting for a certificate of occupancy. So exhibit number 8 is their variance plan, and it's showing the proposed screening fence around each backflow preventer. And then they're going to basically plant the plantings that would have been provided in front of those to the sides of each of those areas.
So that's what the fencing will look like.
Right. And I think they may have already installed this out there. The fencing's already installed. And you may be able to see that in the sign picture. I can't remember if it's in there or not. There's just a close-up detail, again, showing that distance of only 2.3 feet from the back of the sidewalk to the face of the backflow preventers on both sides of the road. So this is the kind of south or east side, and this is the north or west side of DeWitt. For granted variance, all 4 standards for granting variances should be met in order to grant it. And I'll give you a minute to look over the findings of fact before I go through those.
Yeah, why do we keep missing these backflow things? How do we do this?
I'm going to defer that question to Solomon because he's more familiar with the land development review process than I am.
I think it's a twofold problem. I think sometimes show or some things on designers scale it out and like you see a tree that's 5 feet. So
In this case, it was built the way they showed it on the plan.
well, there's trees, not trees, shrubs. So that shrubs technically you have to have that 5 feet. So a reviewer would have said shrubs have to be in 5 feet, and they would, you know, some you give people the benefit of the doubt. Sometimes say, hey, I've scaled it out, it's close. And that's, and like I said, then we go out there and build it, and we find out they were inspected, our inspectors, and that's how it appears. So
This
we
is,
try to catch this, we were staff, we try to catch that before it gets through.
but it's water's responsibility to catch that, yes?
No, it's ours, it's land, so it's zoning.
Yeah, and one thing I did notice on the land development plan submittals, the original submittal did not show the backflow preventers. They were added on a subsequent review submittal. So it's possible that, you know, whoever was the reviewer was at the time, you know, didn't see the backflow preventers on the first submittal. So they didn't have any comments because there was nothing to comment on. And then they just missed it whenever that second round of review came in. Is also possible. They're so small, it's kind of hard to see sometimes what, you know, even what they are. And whoever the reviewer is aren't familiar with some of the technical terms on the utility plan, and a lot of zoning reviewers, you know, they don't review or know all the details of a technical utility plan, but they know the site plan. So sometimes there could be differences with what's shown on each individual sheet as well.
Well, I echo Mrs. Trichet's concern. I mean, this is not the first one of these we've seen. We've seen multiple ones of these in the last several months. So I would like to hope that zoning could do a little bit more training on these things and let's be a little bit more fastidious in looking at these. If it's not there, then where is it? Because there's gonna have to be these boxes everywhere, so. um, That's my only comment. So go
All-
ahead, John.
You ready? All right.
Yep.
So unnecessary hardship results from the strict application of the ordinance, because the ordinance requires above ground utility structures to be screened by either a 5-foot wide planting strip or in lieu of that, that should be a 3-foot wide. Or in lieu of the 5-foot planting strip, a combination of a screen wall and a 3-foot wide planting strip. The approved land development plans showed the backflow preventers approximately 2.3 feet from the back of the sidewalk. And the approved planting plan showed screening shrubs around those backflow preventers. And the preventers were installed as close as possible to the setback and the back of the sidewalk according to Charlotte water standards, which require those to be located as close as possible to the meters. Relocation of the backflow preventers to meet the zoning ordinance screening requirement is a hardship because the site's construction is complete and is awaiting final certificate of occupancy, and it could cause compliance issues with other standards and the Charlotte water standards. Hardships from conditions result that are peculiar to the property. Both parcels are shallow. The parcel on the east side of DeWitt Lane is approximately 91 feet deep, and the parcel on the west side of DeWitt Lane is approximately 129 feet deep. The development of parcels required the widening of DeWitt Lane to accommodate on-street parking, an 8-foot planting strip, and an 8-foot wide sidewalk along the street frontages. And the areas for vehicular site access are basically behind that in the buildings. And there's accessible parking that reduce the depth of the space behind the sidewalk and the setback. And Charlotte Water, again, requires those backflow preventers to be located as close as possible to the setback. The hardship does not result from actions that were taken by the property owner or the applicant. The site was reviewed under the standards of the legacy zoning ordinance and received land development approval. The approved plans showed the backflow preventer locations at approximately 2.3 feet from the back of the sidewalk or setback, and it does not provide the space for the screening that was required by the ordinance. The development proceeded, and proximity of the backflow preventers to the sidewalk without the space for the screening was not discovered as an issue until the final site inspections. It's not apparent to the staff or applicant as to why or how the location of the preventers and the space for the screening did not come up during the plan review. The applicant acted upon good faith proceeding with their approved land development plans, and Charlotte water standards are that backflow preventers are located as close to the connections to the public system as possible. The requested variance is consistent with the spirit, purpose, and intent of the ordinance, and that public safety is secured and substantial justice is achieved. The applicant's variance exhibit plan shows a 6-foot high white opaque vinyl fence shall be provided around the screening for the backflow preventers, and the applicant has agreed to condition that plantings shown on the approved plans will be provided nearby to the preventers as shown on the variance exhibit I showed you earlier. And granting the variance would not adversely affect the public sidewalk, adjacent properties, and granting the variance would not alter the character of the neighborhood. And there's a sign on the property. You can see this is one of the screening fences already installed. And that concludes our presentation.
So there's not going to be any greenery in front of it, just to the side?
Yeah, there's just simply not space
Not
to
space,
plant
right?
anything there.
Does the new UDO change any? This is all the same in the new UDO,
Spacing is different. I'm not sure exactly what it is.
but it's roughly the same. Okay. And do we have different standards for more urban environments than suburban environments or? Gotcha.
I believe utility structures are in Article 17, I think, of the UDO. And so it applies broadly to all the different zoning districts.
Is that an 8-foot sidewalk right there?
Should be 8-foot wide planting strip and an 8-foot wide sidewalk.
Yeah, I would imagine these are really conspicuous things and they're less conspicuous when we have more land and suburban style development, but when we get real dense and urban style, they're harder to fit and more and they're more conspicuous in urban environments, so it'd probably get more complaints. They might have been a little off in the past, but you just didn't notice.
Yeah.
They may not have gotten down to the exact foot on where they put it. But they got to now, and if you don't, they see it, people.
Any other discussion or questions? Is there anybody opposed to this variance today, John?
Not that signed up, no.
Okay. Okay, discussion, or do I hear a motion to approve or disapprove?
Motion to approve.
Okay, second.
All right, Mr. Williamson, motion to approve.
Can we clarify whether that's with the condition?
Yes, that is, I would assume that
Motion to approve the variance.
with conditions, yeah, the applicant has agreed to the condition that planting shown on approved land development plans shall be provided nearby
That's
as written.
As
So, yeah, as written. So we approve as written. All right. Okay, Mr. Court,
Court, yes.
Ms. Young, Ms. Sun, I'm sorry,
Yes.
Mr. Shea,
say yes.
Mr. Williamson,
Williamson, yes.
Dryden, yes. So the variance is approved. All right, we need to now approve the finding of facts and conclusions of law. Do I hear a motion?
I don't know if we want to leave 13 in there.
Okay, let's look at 13.
Just want to make sure that you guys want to leave it the way it is.
It is not apparent.
Leave like that.
You, okay.
Just a quick reminder, if we could all speak into our microphones, that would be helpful for the record.
Okay, so we will leave number 13 in finding of facts and conclusions of law as written. Do I hear a motion to approve?
Court move to approve.
Thank you, Mr. Court. Do I hear a second?
Second.
Ms. Sun, second. All right, Mr. Williamson,
Williamson, yes.
Mr. Shea,
Say yes.
Ms. Sun,
Yes.
Mr. Court,
Court, yes.
Dryden, yes. So the finding of facts is approved. Thank you very much. And let's work on not having a whole lot of those pop up some more. Okay. All right. All right, Ms. Montague, you may continue.
Good morning. This is case number variance 2025-00038. Adam Borman, represented by David Murray of Murray Law Firm, located at 665 Melbourne Court, owned by AKB Property for LLC. Variance from Article 4.3, Table 4-2 to reduce the rear setback from 35 feet to 12 feet, a 23-foot reduction. The condition that the use of the property is limited to a single-family detached home and associated accessory uses and structures are permitted. Exhibit 1 shows a vicinity map. It is close to Sedgefield Elementary School off of Marsh Road. The zoning is N1B, Neighborhood 1 zoning district. Here's an aerial map of the property. And a close-up of the site on Exhibit 4. The variance request is to reduce the rear setback from 35 feet to 12 feet, a 23-foot reduction, with the condition that the property is limited to a single-family detached home and associated accessory uses and structures are permitted. Here is the zoning district's sitting standards table. It's N1B zoning, so the rear setback is 35, according to the UDO. The plat recorded in 1947 shows the lot. 21 in Block 4A. Here's the lot. It's legally non-conforming as it relates to the minimum lot size of 8,000 square feet for the N1B zoning. The lot size for this is 6,525 square feet. On Exhibit 7, this is the survey with and without the variance. So without the variance, the buildable envelope is 1,170 square feet. Right here. And with the variance, the building envelope would to be 2,600 square feet. All four standards must be met for granting a variance. And if you'd like to take a look at the findings of facts now,
We go back to the previous drawing, please.
sure.
Help me understand, just refresh my memory, you don't have a choice about picking what is side and what is rear, correct, Solomon? Short, that's what you said.
The only time you get a choice is if they're equal, the frontages are equal, then you can work with the zoning administration staff to choose which one you want to use.
And I'm assuming what they're going to do is tear down the old house and build a new one? Is that, or do you have any knowledge of that?
We do not.
Okay, okay. Because I guess my question is if they stayed with the footprint of the house that's there.
Okay.
Right, as long as you stayed with that footprint, because it could be grandfathered because it was built before the ordinance was designed,
So,
no?
No,
so
Well,
I
I mean,
just,
if you don't, maybe you could take it down to the the pad, couldn't you? No,
no,
no, okay. So you could, okay,
yeah, so this is, I'm gonna make the assumption that they're building, but we typically, that they're gonna build a new house, but the answer, once they tear it down, then they have to come compliant with the standards of that's applicable at the time.
okay. Thank you, I was confused. All right, continue.
Unnecessary hardships result from the strict application of the ordinance due to the size of the site. Because the front corner, side, and rear yard setbacks restricts the building envelope. Without the variance, the building envelope is 1,170 square feet and is small and impacts the ability of the site to be developed for additions or new home construction. With the variance, the building envelope is 2,600 square feet. The depth of the permitted building envelope is 17.5 feet, which is smaller than the neighboring building depths measured using GIS, which average approximately 68 feet in depth. The existing house built in 1944 is encroaching into the rear yard of the property at approximately 12 feet from the rear lot line. The placement of the home on the lot is legally non-conforming as it was constructed prior to the zoning regulations in the city of Charlotte. The hardship results from conditions that are peculiar to the property. Because of the small size, square shape, and corner location of the lot, which creates a small building envelope for the property. Per Mecklenburg County GIS Polaris, the recorded plat was created in 1947 prior to the zoning regulations. The lot is legally non-conforming as it relates to minimum lot size of 8,000 square feet for N1B zoning. The lot size is 6,525 square feet. The hardship does not result from actions taken by the applicant or property owner. The hardship results from the small size of the building envelope and lack of depth of the property, which creates small building envelope. The applicant and property owner did not create the lot, nor did they construct the existing home on the lot. The property owner acquired the property in 2023. Per the UDO standards for granting a variance in Article 37(8)(a)(13), the act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance shall not be regarded as a self-created hardship. The requested variance is consistent with the spirit, purpose, and intent of the ordinance in that the public safety is secured and substantial justice is achieved. The requested variance matches the existing established rear yard line of 12 feet, so it doesn't exceed the established rear yard. The applicant has offered and agreed to the condition that the use of the property is limited to a single-family detached home and associated accessory uses and structures are permitted. Granting the variance will not alter the essential character of the neighborhood. Here is the sign posted on the property, and that's the end of the presentation.
Yeah, stop right there. That's what I want to see.
John, was it staff's position to offer the 12 feet setback, or was that requested of staff?
The 12-foot setback was requested by the applicant because of the placement of the existing home. They don't have a plan to demolish the existing structure, so they want to be able to, potentially, renovate or do additions to that existing structure. The ordinance says in Article 38 that a legally non-conforming structure shall not undergo a renovation. The word renovation is not defined in the code. However, I think some minor renovations like a bathroom upfit or something would probably be permitted. What's not permitted, like we were talking about earlier, is like taking things down to the studs and major renovations. Those would not be permitted as it currently would stand as a legal non-conforming structure. So this would bring the existing home into conformity and allow them to renovate it or do some additions to it, or it would allow them to build a new home on the parcel.
Beautiful.
Well said.
Okay, do I hear a motion to approve or to disapprove this variance?
Make a motion to approve.
Thank you, Mr. Shea. Do I hear a
Can we
second?
confirm whether that's with the condition? You
As
could-
written.
As,
As
Mhm.
written.
Yep,
I don't-
Melissa's new verbiage, it should be as written. Please
correct.
advise council.
So I think the issue that I have with that is I don't see a written motion anywhere. So I think it's as what is written. So I would suggest that you make a motion to include or to not include the condition.
This is staff recommends approval of your variance request with the condition, the use of the property limited to a single family detached house.
I still would prefer that the motion incorporate whether or not the condition is included. So if you could do a motion to approve with or without the condition, that would be preferred.
For the legal Hawks and Eagles, I will make a motion to approve this with the conditions outlined and approved by staff.
Thank you.
Court second.
Thank you, Mr. Court. Mr. Williamson,
Williamson, yes.
Mr. Shea,
Say yes.
Ms. Sun,
Yes.
Mr. Court,
Court, yes.
Dryden, yes. Approved with the conditions as written. Okay, we need to approve the finding of facts and conclusions of law. Do I hear a motion?
Court moved to approve the,
Approved as written or with conditions, with conditions. Right?
One second.
Say, Mr. Court, go ahead.
There
Uh,
are not any conditions with the findings of, well, I think the findings of fact are as proposed and as written.
Okay,
right. Yes, move to approve the findings of fact and conclusions of law as written in the variance.
okay, as written. Okay,
Second.
thank you, Ms. Sun. Mr. Williamson,
Williamson, yes.
Mr. Shea,
Say yes.
Ms. Sun, Mr. Court.
Court,
Dryden,
yes.
Okay, so the finding of facts and conclusions of law are approved as written. Okay. Thank you. Just give me a second. Approved with conditions.
Yes, I understand what page is on.
Okay, all right.
Ready?
Yep, I think we're ready.
The next case is variance 2025-00039 for Huntington National Bank, represented by Eddie Moore of McAdams. Shift this up a bit. All right, they are seeking two variances, both for the frontage setback lines. A variance from Article 6.3C, Table 6-2A for the frontage setback line measured from the future back of curb for CG zoning of the UDO, to reduce the frontage setback line from the required 36 feet to 28 feet, which is an 8-foot reduction from the back of future curb line along Providence Road. And then a variance from Article 6.3C, Table 6-2A, frontage setback line from the future back of curb for CG zoning to reduce the frontage setback from the required 36 to 20 feet, a 16-foot reduction from the back of the future curb line along Cottage Place. And the reason those are listed out separately is that those are two different street classifications. Providence Road is, I think, a 4+ avenue, say it in here, yeah, 4 or 5 lane avenue. And then Cottage Place is a other primary. So there are two different lines basically in the table. Table 6-2, it's two separate lines, but they're both require a 36-foot frontage setback. The site is off of Providence Road, just before you get to the, if you're heading south, just before you get to the intersection with Queens Road. And the zoning of the property is CG Commercial Center zoning district. There's an existing building on the property. I think currently, or the last thing that was in there was a Sprint store. And then there's a small parking field at the back of the property.
Bye-bye tree.
This is the table I was referring to a minute ago. So table 6-2 in the CG zoning district. Line A, frontage setback line for a 4 to 5 lane avenue requires a 36-foot frontage setback. And then other primaries also a 36-foot frontage setback. And those are both measured from that future back of curb line. So here's a sketch plan on Exhibit 5 of the showing the top, shows the existing building, or actually the existing building is this magenta dashed line. And it kind of goes around the front. It's pretty much the same except for this little vestibule area right there. And then the side wall will get shifted north. And then the rear wall stays as is. And then they're bringing the wall against frontage place in towards the middle of the site as well. The red lines here indicate the required setbacks. And you can see the existing building doesn't comply with those UDO required setbacks, nor is there space for the proposed building within that setback. The applicants also plan to maintain the existing driveway off of Cottage Place and the existing parking field in the back. What they're proposing is in green. So maintaining this side and rear setback, that would bring the side yard into compliance because they're going to be bringing that building up to that 10-foot required side setback. But they are asking for that relief on those frontage setbacks to accommodate the space of essentially where the existing building was, but they are again reducing the frontage on the setback or increasing the setback from the existing along Cottage Place. The existing building square footage is 3,257 square feet. The proposed building is smaller. It's 2,680 square feet. So again, they are trying to shrink the building down some to try to meet the setbacks as much as they can for the site.
There, looking at that, there is no entrance to this building off of Providence Road, correct?
There's a doorway right
No,
there.
I mean from the street entrance.
I'm sorry, I'm not sure what you mean.
Well, if you were coming at Providence Road, could you turn
Oh,
into this?
vehicular access.
Vehicular
No,
access.
no, there's not.
I'm sorry, yes, I was talking about vehicular.
No,
access.
there's the only driveway is off of Cottage Place and it would be that existing driveway.
Okay, thank you.
Is there a future back of curb widening of Cottage Place there?
Yes, so the red line is indicating that future back of curb line. The existing back of curb is this light gray dash line that's up here. So the looks like. Yeah, I'm not sure how much the curb line shifts, but it definitely shifts in towards the property.
Okay.
So the future right of way line or future property line is this blue line, whereas the existing right of way is this middle dashed line here, black.
Is Providence Road being widened?
Providence Road looks like it stays as is. Future back of curb looks like it aligns. Actually. No, existing back of curb is here. and the future back curve is, so it Providence Road would be widened at least. According, now, I don't know if they'll actually construct that because a lot of times the ordinance requires you to basically match your setbacks off of the future back of curb location. But in actuality, that construction of that may not occur because, you know, NCDOT or CDOT doesn't want to create, you know, additional pavement in places until there's like a larger section of the block length to widen. So I don't know for certain if the widening will occur with this project. But they have to match their setbacks off of that future back of curb per that table 6-2.
Any other questions before he continues? Okay, go ahead, John.
So all four standards of the variance need to be met. Unnecessary hardship results from the strict application of the ordinance because of the size of the parcel. Application of the required frontage setback lines, the side and rear setbacks, and the location of the existing parking area to remain, limit the buildable area of the lot. According to the applicant's site plan, the frontage setback line along Cottage Place and the side setbacks limit the maximum building width to 26 feet facing Providence Road. And according to the applicant's application and site plan, the existing parking area at the rear of the site will remain, and the frontage setback along Providence Road, in addition to the existing parking area, limits the maximum building depth facing Cottage Place to only 29 feet. The resulting building footprint would be limited to 1,696 square feet with the required setbacks and maintaining that existing entrance drive and parking area. And if the variance requests are granted, the applicants would propose a 2,680 square foot building within that same area essentially. Huntington Bank has worked with the planning staff in exploring options to try not to trigger a variance request, such as modifying the existing building, renovating it as is, but with their plans to remove walls of the existing building, it would not meet their criteria for a renovation. And so because of the non-conforming structure clause, a major renovation would be considered new construction essentially. Hardship results from conditions that are peculiar to the property because the lot is on a narrow corner lot with a frontage setback requirement of 36 feet from the future back of curves along both Providence Road and Cottage Place. The lot's width along with Providence Road is 72 feet wide, and there's the existing access driveway off of Cottage Place and the parking lot to the rear of the site that would remain.
Questions, or do I hear a motion?
I was
Okay,
trying
something
to
else,
move
okay,
this
sorry.
out of the way. Can't get it down any further, did at the top. The requested variance or the hardship does not result from actions that are taken by the applicant or property owner. The hardship results from the narrow lot and implementation of the UDO setbacks, and the applicant and the owner did not create the narrow lot. And the property owner acquired the property in 2012, and furthermore, the UDO standards for granting a variance and 37A13, Roman numeral 3, the act of purchasing property with the knowledge and circumstances that exist that may justify the granting of the variance should not be considered a self-created hardship. Requested variance is consistent with the spirit and purpose and intent of the ordinance in that public safety is secured and substantial justice is achieved. The existing building is 3,257 square feet and is legally non-conforming in relation to the frontage setbacks along Providence Road and Cottage Place and the side setback. The proposed building will comply with the side setback and be approximately 3.5 feet away from Cottage Place, allowing more space for that should be be approximately an additional 3.5 feet further away. There's probably a missing word there.
Say it again, the proposed building will comply with the.
And the proposed building will comply with the side setback and be approximately, I don't know if we need to say an additional 3.5 feet further away from the Cottage Place.
I think it reads correctly to me. It will
Okay.
be approximately 3.5 feet further away.
Yeah,
from-
that's right.
Okay, yeah, I guess that does make sense. The position of this proposed smaller building improves,
Farther instead of further.
creates, now there's a missing word. The positioning of the proposed building improves and creates an increased building. There should be an and in between improves and creates. Improves and creates an increased building separation and improves fire safety from the existing building to the south located on parcel 155063002. That's 811 Providence Road. And the requested variances will allow the ability to utilize the existing vehicular entrance off of Cottage Place and parking field. And granted, the variance would not alter the essential character of the neighborhood. Last slide is just a picture of the property, and that concludes our presentation.
So they want to build a bank in there?
So that was, let's see, what number was that?
So I think I get this point here. This
18.
does not have a condition. So.
No,
it's-
yeah, no condition on this one.
So I get what you're saying now. Okay.
Correct.
So I'll make a motion to approve as is.
Okay, Mr. Shea makes a motion to approve as written. Do I hear a second?
Court second.
Thank you, Mr. Court. Mr. Williamson,
Williamson, yes.
Mr. Shea,
Shay, yes.
Ms. Sun,
Yes.
Court,
Court, yes.
Dryden, yes. So it is approved. All right, before we approve the finding of facts and conclusions of law, let's go back to number 17. And that word, it should be proposed building will comply with the side setback and be approximately 3.5 feet farther away, not further away. The verbiage there should be farther. And then you said in number 18, the positioning of the proposed smaller building improves and creates. So we're gonna add an "and" in there. And increase building separation. Okay. Do I hear a motion to approve the finding of facts and conclusions of law as amended?
Court moved to approve as amended.
Thank you, Mr. Court. Do I hear Mr. Shea? Thank you. Mr. Williamson,
Williamson, yes.
Mr. Shea,
Shay, yes.
Ms. Sun, Mr. Court,
Court, yes.
and Dryden, yes. So the finding of facts and conclusions of law are approved as amended in number 17 and number 18. Thank you very much.
That is the post, well, the next two are on the regular agenda, so we have full hearings for those.
Right.
Y'all want to take a quick recess or not?
Yes.
Anybody signed up in opposition?
Okay. Yes, we'll take 10 minutes. Thank you very much.
Yeah, still. No breaks. Let's keep moving. Let's go.
We get done before 11.
We got some momentum here. What we need is another bank branch on the corner.
No,
Or church.
it's like a fast food. You need a fast food place.
Not right there.
I'm just curious.
Different banks moving here.
Yeah, so there is,
Little banks.
this one.
Yeah.
This actually.
You know, out by us, and here's school bars and,
Just came.
That's right. I guess.
So it was.
Here, there was
So it is.
BB
it is
and
required.
C.
But that
They
particular.
torn that down.
Watch.
You some kind of school bus.
Yeah, this is the second.
Yeah.
Yeah, so.
And use that.
Sale, oh, well, it's on my client, so you just gotta. I'm talking to Bank of America always on the side. And that's very commonly. That's what they're saying. That's where it's at. Yeah. Where they have it. Yes, that's, it was a well started.
Yeah, well.
Yeah. So I don't know, you know.
That's the one.
The buildings for sale, they haven't put up the signs or anything else.
I didn't say that.
Yeah, it's in the
I just
posted
didn't
line.
mention it, said the parking was good because.
Right.
You don't need all the parking.
Right.
If you don't have that drive, you're back. Center outside.
They, they coded for citizen rank out there by the Target.
Still underneath.
Exactly my right. Now, my kids laugh at me all the time. But they swear. So I don't know about what's in it. And so now, because they'll show you on the bank and you go and then I can do that. Now I have to take that. Go to East Way. And come right around. And then I have to-
How's it going? Doing well. Settling in.
I know.
I had no idea if I would have needed it.
That's where the old, that's was really bad.
Yeah, if you're gonna put a house on it, which was- Underneath. It's not like that, it would be the back of the house. Back of the house, you know, all of this, I mean, like, yeah. In the slab. But I have another problem, which is my office. I do the slab, I just sure to play that.
Kids doing okay, just back to school life.
Yeah, I think so. We've got a freshman, so starting at East Mex, so that's been, we made him do cross country, so, that's actually turned out to be a good decision. I just wanted him to exercise and I'd forgotten what a good social thing it would be to just kind of make some connections and make some new buddies. So turned out to be really good. And he's liking the sport and running fast, so a lot faster than I thought he could. Yeah. Yeah. Yeah, it's always a gamble. You never know if it's gonna be.
You know, my kids played, of course, back in the day, they played basketball and soccer, and you know, my son is an adult. He came back and said, "Mom, you let me quit playing basketball." And I said, "No, I didn't. I made you finish out the season." I said, "But then you said you didn't want to play the next year." "Well, you should." I said, "No, I shouldn't have. I told you, you know, you couldn't quit in the middle of the season."
Yeah.
You made the decision to not want to participate. And it was like, "Oh, it's your fault that I didn't, you know." And you know, I mean, you may come back to haunt him because his son, Eric, played soccer at the time. He was probably 6 until he was 16. And then last year, he decided he didn't want to play anymore. He wanted to concentrate on school. It's his senior year. I think he was just tired of travel and, you know, every weekend they were going someplace.
Joshua Renaud, Joshua, Renaud, Regnaud.
And David Murray, Murray.
Thank you. All right, and gentlemen, I'll go and swear you in. Do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Thank you very much. Okay, gentlemen, you may sit down there. Okay. All right, Ms. Montague, we're ready.
00037 to reduce the rear setback. The applicant is Ashley Chandler, represented by David Murray of Murray Law Firm for property located at 6100 Sharon Hills Road, owned by Ashley Chandler. Variance is from Article 4.3, Table 4-2 to reduce the rear setback from 40 feet to 15, a 25-foot reduction. The condition is that the variance is for a single-family home and associated accessory uses and structures, and no building, only at grade patio, pool, etc., shall be located in the green area as depicted on the variance condition exhibit. Here's the vicinity map. West 485, around Old Georgetown, off of Sharon Road. The zoning is N1A Neighborhood 1 zoning. Here's a close-up of the property. The variance is to reduce the rear setback from 40 feet to 15, a 20-foot reduction. Here is the table 4-2 building siting standards. The minimum rear setback is 40 for N1A. Here is the applicable ordinance section in Exhibit 5, where on the table at the bottom, there shows footnote 1. Platted front setbacks supersede required zoning district front setback. The footnote is not applicable to the corner side setbacks with by right zoning. Zoning allows the applicant to replat the lot to match the district's front setbacks. Ability to do so may be deed restricted. The city does not enforce deed restrictions. Exhibit 6 shows the survey showing the previous home location. The previous home on the lot was constructed in 1970 and was legally non-conforming under the UDO as it related to the rear setback. Per Article 38, nonconformities, except when destroyed by an act of God, non-conforming status no longer applies when a structure is demolished, and new structures shall be compliant. Survey considerations and Exhibit 7 showing the minimum lot size. The minimum lot size is 10,000 square feet for N1A. Per the applicant's site plan tree survey, the lot is 19,679 square feet. The lot is 9,679 square feet larger than the 10,000 square minimum lot size for N1A zoning. So here in Exhibit 8 shows the survey considerations, the building envelopes without the variance. So on the left side, this would be without the variance is approximately 6,684 square feet building envelope. There's a 10-foot wide drainage easement here on the side setback. Building envelope was with platted front setback, platted corner side setback, and 10-foot wide drainage easement, and required rear setback is approximately 6,684, as shown on the left side. On the right side, here is a heritage tree drip line. So to avoid the heritage tree drip line, the building envelope with the platted setback, drainage easement, and required rear setback is 4,921 square feet.
we go back for 1 second?
Sure.
My orientation here is not, I'm just not getting this. This is different looking on Polaris. Where is Sharon Hills?
So, bottom of the page.
Sharon Hills on the bottom?
Yes.
Yellowwood is the right.
Yep.
So it's,
So
I
this
think,
is
if you look at it on Polaris, it's rotated, yeah,
Since,
rotated 90 degrees to the right.
can we put his screen up for purposes of the
Uh,
record since he's reviewing it?
No, we'd have, I don't know, can you close out the PowerPoint with Thomas and things on it? And then if you pull it up on, I guess, Bing,
Where?
Chrome or Chrome, go to Chrome, go to Polaris. Don't sign in.
You have the address?
09.
6100 Sharon Road.
Thank you.
So again, the site plan or survey is rotated basically 90 degrees to the right.
Mr. Shea, can you confirm that that's what you were looking at?
Yes, that's what I was looking at. So the short, just make sure I'm all on the same page here, the short front,
Yellowwood.
Yellowwood, means where the house is sitting tight to the line is now called the rear.
Correct.
Okay. That's what I'm doing. Thank you.
Here is in number 9. It shows that variance condition where is for a single family home with associated accessory uses and structures and no building, only at grade patio, pool, etc. shall be located in the green area as depicted on the variance condition exhibit. And this here is approximately 6,272 square feet. With the variance, excuse me. Here is the 4 standards for granting a variance, if you'd like to look over the findings of facts.
Have it right on mine, yeah.
You can go back to where you have the 2 pads. One more, I think it's a couple more back.
Yeah, that
so you
one.
go.
So
The-
which is the one that they want to approve? The one
The
on the right?
next slide.
This-
So this is the one they want. That's their variance request. The other 2 are just 2 different scenarios with the required ordinance setbacks and the platted setbacks. The one on the left is ignoring the heritage tree and building within its strip line, which is not advised by urban forestry, to fully preserve it and make sure that everything is good with the heritage tree and allow that drip line space. The one on the right would just be the building envelope with the required setbacks and the platted setback, taking that heritage tree drip line into consideration because the applicants have indicated in their application that they do intend to maintain that heritage tree.
Okay, well, yeah, I want you to point that out to me where it says it in the finding of facts that they've agreed to do that. When
They
we get
haven't
there.
agreed to it as a condition of the variance request, but they indicated that was the intent in their application.
Can you advance to the next slide? That's 49 and then
And then-
it's 62. Okay.
So what they're asking for is what's in the green now?
In the green on the right.
Okay.
And then
And
back
the
to the previous,
condition
sorry.
of the
So that's
left is where they-
6,200 square feet and go back to the previous. Okay, and the initial is 6,600 and then your illustration is that it's 4,900. Okay.
So it's essentially the building envelope with, not taking into consideration the trees drip line, the building envelope with or without the variance is about the same, 6,272 versus the 6,684. The real difference is that the variance request would allow them to basically put the house in, and with the condition, put the house basically in the same location as the pre-existing house was. However, again, like we established before, once you demolish a structure, your non-conforming status goes away and you have to comply with the ordinance standards, and the ordinance standards would require either one of the building envelope setbacks or standards that we have shown here.
And if they lose the heritage tree, they have like $1,000 to take the heritage tree down.
I'm not sure what the payment in lieu is. There is a cost to pay.
Cost
Yes.
of mitigation, yes.
Okay,
Necessary hardships does result from the strict application of the ordinance. The lot is sufficient shape and size to accommodate a single-family dwelling. According to the applicant's site plan tree survey, the lot is 19,679 square feet. The lot is 9,679 square feet larger than the 10,000 square foot minimum lot size for N1A zoning. The required front setback parallel to Yellowwood Road is 40 feet per the recorded plat, which supersedes the zoning district front setback of 27 feet. Zoning allows the applicant to replat the lot to match district's front setback. The zoning required corner side setback parallel to Sharon Hills Road is 13.5 feet. The recorded plat shows a 20-foot corner side setback. The side setback perpendicular to Yellowwood Road is 5 feet. However, there is a 10-foot wide drainage easement that runs parallel to the side property line. The zoning required rear setback is 40 feet along the property line perpendicular to Sharon Hills Road. The building envelope resulting from the application of the platted front setback, platted corner side setback, the 10-foot wide drainage easement, and zoning required rear setback is approximately 6,684 square feet. The building envelope has approximate dimensions of a deck of 47 feet along the platted corner side setback parallel to Sharon Hills Road, a 92 feet along the 10-foot drainage easement, 81 feet wide along the platted front setback parallel to Yellowwood Road, and 129 feet wide along the required rear setback. The applicant has expressed a desire to maintain the existing heritage tree located at the front corner of the lot. Considering the tree's drip line depicted on the applicant's site plan tree survey, the building envelope would be reduced to approximately 4,921 square feet, with approximate dimensions of 57 feet parallel to Sharon Hills Road, 92 feet along the 10-foot drainage easement, 46 feet wide parallel to Yellowwood Road, and a 96-foot wide along the rear setback. The hardship does not result from conditions that are peculiar to the property. While there is a large heritage tree on the corner of the lot that the owners are seeking to protect, there is space for a single-family dwelling on the lot within the platted and required setbacks. The hardship does result from actions taken by the applicant. The hardship results from the applicant's desire to place the new home in a similar location of the previous home, which was located approximately 13 feet from the property line. The requested variance is consistent with the spirit, purpose, and intent of the ordinance in that the public safety is secured and substantial justice is achieved. The requested variance would allow the placement of a new single-family home in a similar location as the previous home, consistent with the context of the property in the neighborhood, dating back to 1970 when the previous home was originally constructed. The lot is located on a corner with an existing heritage tree and the requested variance would facilitate the protection of the tree. Granting the variance would not alter the essential character of the neighborhood. And the applicant has offered the condition that the variance is for a single-family home and associated accessory uses and structures, and no building, only a grade patio, pool, etc., shall be located in the green area as depicted on the variance condition exhibit. Here is the sign posted on the property. And I'm gonna go back to the condition and their requests.
We don't have a single overlay that shows what they want and what the zoning allows, correct?
No, but that would be a good graphic to add, wouldn't it have been? Sorry.
Mr. Murray have one maybe?
So what's the question, showing what we want with the line over it, with the variance?
A green box and a red box that shows
Uh,
what zoning is allowed and what.
I'm not sure we have a green box and a red box, but what our condition is essentially to have this be the site plan, to be approved as a site plan. It includes the heritage tree. It means that the house stands exactly where it is, that everything that's open stays open, the driveway is shown where it is, which pretty much matches. We do have a plan that shows the overlay of the prior existing with the proposed, because that was the intent here. And I can get into it more, but basically, there was a misunderstanding about whether this was a triangular lot that had a rear radius.
Mr. Murray,
yard.
sorry to interrupt. Can you talk into your microphone?
I'm getting into my presentation here, but what triggered this whole thing was that there was a survey that showed the rear yard as a radius in the back. And so when they proceeded to their LDIRL approval, it got flagged. But in that time, the existing house was torn down. And so when it got flagged, we had to come in here and ask for a variance, but the whole intention was to match the new house in the location as the old house. Because this lot has always functioned as a triangle, not as a rectangle. Because it's a unique shape, because zoning applies a rear yard to the longest effectively side lot line. So a large part of this property is eaten up, including the prior existing house, by the fact that the rear yard is the longest lot line on this lot because of the unique shape of the front. Under zoning, this curved front lot line is not considered a triangular lot line. So even though we designed the house, meaning my client and his builder designed the house to meet a uniform zoning front setback, the only front setback is applied on the shortest lot line. This is a side yard. And then this long line that effectively has operated for 70 or for 50 years as the neighbor's side yard is actually the rear yard. And all we're looking for is really a carve out to allow this house to sit in the portion of that rear yard. And everything else remains the rear yard. So this green area is showing the non-built area, but really there's some green area up here too in front, because technically their front yard, for purposes of operation of this house, would be the rear yard. And that's how this has always been oriented since 1970 when they built this house. That was how this was lined up. What zoning is now doing is zoning is causing the whole orientation of this lot to be transferred to push any development further into what has traditionally been the rear yard. So this is a rear yard variance, but there's really no rear yard issue at play here. It's really a side yard issue. And so that's all we're seeking to do is the hardship here is you've had a house that had been there for 50 years. We're trying to replace that with a house that matches the rest of the neighborhood. But we can't do it because the way that zoning, the UDO orients is the longest lot line is the rear yard. And so that's all we're looking for is just a carve out of that rear yard and to effectively adopt this as the site plan to allow that house
I
to
want to
exist.
take you one step further.
Yes.
and Right now you have a Sharon Hills address, yes?
Yes,
But zoning is forcing you to look out onto yellow, whatever it is.
yes. And the other, yes, and once you push, if you were to push a house up, so you're pushing the house up, it's a really kind of odd shaped buildable envelope that you have now also. And the other problem that you're gonna have is, and I have an exhibit, this intersection right here, cars fly through here, they have a picture that's in our presentation that someone hit the fire hydrant. So we're trying to stay away from that intersection. We're trying to keep the house where it is today so that we're not pushed up on Yellowwood, because then we're gonna have to shift our driveway over to Sharon Hills. And it would be better to have the driveway off the cul-de-sac as opposed to the main thoroughfare. So I basically run through the majority of my presentation without showing all my slides, but that's pretty much where we are. And staff's not really in opposition to this. It's just a unique circumstance, and that's why we're here for a variance, is that this lot, the buildable envelope has never been where zoning is now requiring it to be. And as part of our conditions, we're effectively flipping the lot. We're saying, let it be built in the area that it's been before, and we'll preserve we'll call it the established rear yard that's existed on this property. And I can tell you the neighbor that's on the side where we might be shifting towards would prefer that we stay where we've been. And they've provided a letter in support. That neighbor would be this one shown over here on the side, because the two driveways are next to each other on that side of the property. Once you rotate things, now the whole development of the site shifts towards Yellowwood, and it's never been that way.
Where's the driveway? Can you just point it out?
Yeah, I can flip through.
Well, I mean, just on that one, just point
Oh,
it,
yeah.
just show me.
Driveway would be to the top.
Okay,
There's a pointer
Off
here
of the
too.
other-
The laser pointer.
Brightest green pointer. I can barely look at it. But yeah, right there.
Okay.
I'm taking a picture, flash, in my eyes, but yeah, the driveway's up there. And the driveway had always come the full length of basically the side yard. It
Okay.
is the side yard. But it operated as the rear yard. And you can see, also GIS is not correct. This is not a pointed front lot line. That's incorrect.
it's a curve, yeah, I
It is
saw
a
it.
curve. One of the other things that's kind of interesting, I'll click through this. Again, David Murray for the petitioners here. I left out Josh's last name. Ashley's name was on the documents first. Josh is here with me. But staff went through, but basically what happened was house existed in 1970. This is slide. My slide numbers are covered up, but now slide 3. They sought a builder and a surveyor. And when they did the survey, they were under the impression that it was a triangle lot, because this lot functions as a triangle. If it's a triangle, your rear yard line is measured from the rear point. That's not what actually was in play, and that was flagged in the LDIRL approval process. And in that time, the house was torn down. And so simply this hardship now is, and even if the house was there, it would still be the same circumstance. But the hardship is you cannot build the house in the location as the prior existing house without this variance. And so you're basically rotating and you'd be shifting the development of the house into what is operated and what was originally developed in this neighborhood as the rear yard. And you can see here the front lot line is not really a point. It's more of a bend.
Can we turn on the screen sharing again? It got paused.
Oh, okay, cool. Sorry.
Sharon Hills, okay.
Okay. Thank you.
Oops, I'm
No, you're
sorry.
good.
Okay.
This lot, slide 5 is just the aerial, which we've seen before, which we pulled up. This was the house before it was torn down. This effectively, this was 13.4 feet from the side yard. What's proposed is 15 feet. This is functioned as the side yard between the house on Sharon Hills. This is an aerial showing the lot prior to the house being torn down with the triangular point in the backyard. With the house that's on Yellowwood shown in
That's
this
the house
picture.
that was torn down on the.
This is the house that was torn down. This is the subject site.
Now, where's the driveway?
This is
for
the
that?
driveway that comes in off Yellowwood,
Okay,
and that's going to be kept. So the driveway would be kept in the same place, and the neighbor's driveway is on that side. So their driveways were next to each other. And if you go out there today, that driveway is still there. Here's an aerial of the site. This lot on the corner here is actually, has more of a bend, and it has a radius rear lot line. So 3 lots down, there's a radius. And this is what the area looks like. There's a fair amount of redevelopment and new construction in this area. This would be aerial. That would have been 7. Again, if further zoomed out, this was the lot I was talking about, more bend, radius rear lot line. This is the aerial of the surrounding area, which is exhibit 8. This is exhibit 9 is showing where the functional rear yards have been on the adjacent property as well as this property. That's really what we're seeking to preserve here by doing this variance. It's keeping the orientation of the site the way that it is, or the way it has been. This is a picture before the construction of what the rear yard buffer area. This would be looking towards the left side would be towards the Sharon Hills house. This would be looking towards the Yellowwood house. This is exhibit 11. This would be the prior existing house with the garage. The green line shown in the middle is where the rear yard would have been in relation to the prior existing house. You could see it basically runs about 40% of the prior existing house. This is the proposed plan showing a 15-foot rear yard. And like I said before, this would be effectively the condition being that this is the site plan, that we keep the driveway entrance where it was. The house stays up. It's actually a little bit further from the Sharon Hills property than it was before. And then no structures in that 15-foot area, and then beyond the back of the proposed new house. No buildings. This is the big tree that's at the front corner that is part of the condition. We can, whether it's written or whether it's done as part of the site plan, the city wants this preserved. We want it preserved. And so the intention is to keep this heritage oak tree. This is, cars come flying around this corner, even though there's stop signs. This is the hydrant that was run over recently when there was an accident in front. So we want to make sure that the house is built away from that corner. And what we had the surveyor do here was add some dimensions. This is exhibit 16, add some dimensions to the back of the house so that if this is adopted as the condition, which would be the site plan, for purposes of construction, it can be staked off so that there's no confusion about where the spacing needs to be for the back of this house in order to preserve the back area of the lot for purposes of development. This is number 17. This is just another exhibit showing on the proposed house where the rear lot line would be. Which is basically kind of to the midpoint of the existing house, maybe about 40% also. I mean, sorry, of the proposed. This is a little bit hard to see, but this is exhibit, I believe it was 20, but it's the overlay, and it's showing the prior existing house and the proposed existing house. So the prior existing is the blue, the proposed is the black, and what you see in this blue area on the top, I guess at the top of your screen, would be the driveway coming in. The driveway as it exists prior was actually a little bit closer to the adjacent house, and then it had a garage to the rear. That would be replaced with at-grade patio and pool area, which could have been added to the old house also. Then the rear of the proposed house would be where the blue line would be where the prior decking area was. And the front of this house, one thing I'll note again is if this was considered a triangular lot and the whole kind of curved front line was considered a front setback, the proposed new house is further than what zoning would require for a front setback. So the front setback under zoning would be 27. This house is 30. So it would be further than what is would be required if this had been considered a triangular lot with a complete front setback. The staff used the no building zone exhibit, which is a good exhibit, but it's not perfect. It's easier just to have the site plan. But what it shows is the green on exhibit 19 is showing areas where no buildings would be, basically preserving the effective rear yard on this site compared to what it was before and what is proposed. And then the variance standards and the all zoning ordinances, create some hardship. The question is whether it's necessary. And here it's unnecessary. It's an unnecessary hardship to enforce the rear yard setback on this longest lot line when the prior existing house had been there since 1970. The orientation of the lot has always functioned as a triangular lot, and the house proposed fits that same envelope as the prior existing lot. Without it, you're totally reorienting the site. You're shifting all development to the other side of the lot, and your buildable envelope, and Mr. Kinley did a good job on his exhibit. The variance buildable envelope doesn't matter as much as the footprint of where we're building the house, because we're not seeking a condition to allow us to build on 6,000 square feet of land. We're allowing us to build where the footprint of the house previously existed. So unnecessary hardship, slides 21. Hardship runs with the land. It's directly related to the conditions that were at the property, the unique shape of the lot, the orientation of the rear yard setback applied by the UDO being on the longest lot line, which has functioned as a side lot line. The house being pushed back further because of the heritage tree. The buildable envelope that's allowable is very uniquely shaped along Yellowwood, which would create conditions and difficulties with the driveway being shifted. And then the soft corner here doesn't actually benefit the property owner because none of the development is towards that corner. So you have a lot of space at the front of this lot that's really set back, which is not going to be buildable under what we have proposed, nor when you're preserving the heritage tree in the lot. So this was Exhibit 22. No self-created hardship. The owner's just seeking to conform to circumstances materially similar to what was there before. Just because you're seeking a variance and you bought a property knowing that the house, honestly, they didn't know the house was in the rear yard. They thought it was in a radius, so they didn't know. But so they're seeking here the variance because of the hardship conditions, not because they've done something that's created this circumstance. They have not. And then we're in agreement with the city on this. It meets the intent of the ordinance. There's not a rear yard concern here. So this is a rear yard setback, but we're preserving what's been functionally the rear yard on this property. What we're seeking is really a rear yard that functions as a side yard. And so the intent of what we're seeking to do here is to match what had been the development plan of this site back to the original 1970s. This was the neighbor to the side. The neighbor that's on the Sharon Hill side is also in support. We're allowed to say this. The problem is their attorney wouldn't let them sign off on anything because they just bought the house and they're suing the prior owner. And that lawsuit was filed about 2 months ago. And so their attorney just didn't want them being involved in anything going on in that area, since they were claiming that the prior owner of the house that they bought next door had misrepresented some things. So the other owner is in support here. They're not here in opposition. And then this would be the owner who would be on the Yellowwood side who's in support. And then our proposed condition would be, Mr. Kinley showed the green area, but effectively to have the survey that was submitted with these measures, function as the site plan to make sure that that area stays clear, that there's no buildings in where has been the effective rear yard, as we would call it. And I also had some proposed findings of fact and conclusions with the conditions that I'll hand out.
Go back one slide while you're doing that, please.
Yes, sir. Oops.
Not the drip line we're looking at.
The squiggly line of the drip line.
Yeah, the drip line, the prior house had already pushed in some, and so the tree protection fence, I think it's out there. It's already out there at the site, has been already established around this tree.
That building, so that,
Can you speak into the microphone, Mr. Shea?
thank you.
Thank you.
Trying to understand that, trying to understand the new building that.
This might have what he just gave us. There we go.
All right, so the courtyard is going to connect to, is that on a garage right there?
So
The rectangle? Yes, that rectangle.
this is the garage.
Okay.
It's connected to the house. And then there's a porch at the back. So this is the back of the structure. So the back of the structure measured, at varying points, varies, as shown on this, various spacing, but there would be no building beyond the back of what's proposed, which is actually shorter than where the garage was on the old house. Or, sorry, longer from the lot lines than the garage was at the old house. The garage was further into the backyard, the effective backyard, than what we're doing now, because the garage was pushed kind of back. And then you had the driveway going pretty much completely along the Yellowwood Road side yard. And that driveway has been shortened now.
And this, the pool area that you're talking about, it says a proposed pool deck.
Yeah,
and
it's just
pool,
at grade.
But no, not a building lot, not a cabana,
Not a cabana.
Okay.
I was gonna ask for a point of clarity. When you say no building in the green area, that would also include accessory structures, correct? That was our
Yeah.
understanding.
Right, yes. Yeah, so we just weren't, we wanted to make sure, is pool defined as a structure?
I think it's.
Pool zigzags
I think
under the
a
UDA?
pool is considered an accessory structure. I guess the more proper term would be accessory building.
Yeah, that's why we
is a
said
building as a
building,
roof.
because at grade would be that would be allowable. It would have been allowable before and now. So basically, at grade would be okay, but no cabana.
Yeah, that's
No.
what I was concerned with, that you would come back to us and say, oh, well, now we want to build an enclosed eating area and a
Definitely not
kitchen
gonna do
and
that.
and I don't, if we approve this, I don't want that to happen. I want it to stay the deck and the pool and that's it,
This would be the site plan. This is what was submitted for LDIRL approval. This is what they were intending to proceed on building. And then that's what got flagged, and that's why we're here today.
So staff's hands are tied because the short front makes that the rear and it's 40 feet setback, correct?
Correct.
That's as simple as that. And if we push them off that line, then they go to the tree.
yes.
They start getting further and farther and farther or closer and closer to the tree. That house is 52 feet. The proposed house is 52 foot wide at the front. Is that correct?
Yes.
Something like that?
Any other, does that complete your presentation, Mr. Murray?
Yes, it does. I was just pulling up the
Oh, okay.
exhibit of where the prior house sat. The prior house actually sat, it was actually a little bit wider than what's proposed. The prior house that was there.
In the description in your application that talks about the triangle and the
Yeah.
radius, that was done by the surveyor?
Yes.
All right. Any other questions for Mr. Murray from the board? All right, thank you, Mr. Murray. I appreciate your time.
Wait, I do,
Oh, you do have a question.
what are the gray squares?
Oh, yeah, the gray squares were the boxes for the planting of some additional trees on the property.
Okay.
Some of those, we took the gray boxes off. It's actually funny. We took them off because we thought that might bring a question as to what they were. And this just crept back in.
So those are additional tree plantings that you plant,
Right.
but the small circle at the bottom is the heritage tree.
Yeah, it's a pretty massive tree. I think it's.
Right, I
fruits.
mean, I know the tree is
Yeah.
massive, but the little circle
Oh,
represents.
yes, that's correct.
It's
That would be
okay.
the,
All right, thank you. Any other questions? Any other questions for staff? Okay, I'm open for discussion.
So for me, I think that it's common for us to see the short lot or the short side of the lot and the long side of the lot kind of confused, and therefore the back lot and the side lots being kind of incongruent with what was historically constructed there. I think what's different here is that the staff feels like the hardship is because the size of the lot being much bigger, that there's lots of buildable area still. I disagree. I think that it does exhibit a hardship. And so I would disagree with that number one conclusion of law. I also agree that with the applicant that that this hardship does result from the peculiarity of the lot. I think it is peculiar in size. And I don't think this was a hardship resulting from the action of the owner applicant.
Thank you, Mr. Court. Any other comments?
Well, I think this has a Sir John, or whatever his name of the street is.
Sunny,
Sharon Hill.
No, Sharon Hills.
Sharon
It's got a
Hills.
Sharon Hills address.
right.
The house has been facing Sharon Hills. Now we want it to, now the UDO is causing it to face Yellowwood. It just seems incongruent to me. And the other thing I was thinking and trying to rationalize is there a way to increase that 15-foot that setback to get closer to what the UDO requires? You know, if it's not 40 feet, could it be 30 feet? Could it be 25 feet? But everything that every foot that we move off that long line is going to move us into that tree.
Correct.
And I think we need to save the tree. Whatever we can do to save heritage trees, that's an important part of this, so.
Well, that was my first thought. I mean, as we looked at this and they did your first presentation, I mean, if you look at the visuals, the closer you get to that tree, the more root damage there's going to be and the eventuality that that tree dies because you've interrupted its root system. And I agree with Mr. Shea. I would love to see it moved, but the closer you move it, the more chance that the tree is not preserved. And I mean, I understand the ordinance, but it to me, it just seems incongruent to say the street address has been this way since the house was built in the 70s. And now all of a sudden, because of a little different interpretation, you got to change, I mean, change everything to orient it toward Yellowwood, I think is asking a little too much at this point. Any other comments? All right, do we have a motion?
Court moved to approve the variance with the conditions that the requested by staff for restrictions on the on what may be built in the, I guess, is it in the no build area?
Right. Okay, and all right. But I want something stated of the condition about, because the applicant has expressed a desire to maintain. A desire doesn't mean they're going to work real hard to maintain it. I want something a little more affirmative that says that that tree is going to be safeguarded. And I don't know I don't know if we can word that. I don't know if we can do that.
I
but-
believe you would need to ask the applicant if they agree to that condition, and if they agree, then you could add it. If that's correct, I'm looking at the attorneys, make sure I'm stating that accurately, but I believe that's how that would work.
When they make application for permit, though, they're gonna have to do a tree save plan for that tree. They cannot get a permit unless they put a tree save plan in and get it approved by Urban. I know that is for a fact, so.
So a board member can impose a condition whether or not the applicant agrees. So you can do that.
The site plan shows the tree protection line that's out there. It's the line with the circles, the little circles, the line, little circles that goes around.
Yeah.
And that's actually already out at the site.
Okay, so can we say instead of the applicant has expressed a desire that the applicant will work to maintain the existing heritage? That
Yes.
express the desire means I kind of wish it would happen, but it doesn't mean you're going to do it. It just
Yes,
means
the
I kind of
intent,
wish it.
the
So-
absolute intent is to keep
So
that tree.
if you would agree to that verbiage, the applicant has agreed to,
May I suggest using the word shall
yes,
comply?
the applicant shall maintain the existing, shall, okay,
You could say shall comply with the urban forestry standards for tree protection.
yes.
Thank you.
Shall comply with urban forestry.
I just want to make sure you're
We're not.
either in open or closed sessions that you're.
I think we're in open.
You're still in
Okay,
I don't think that
Well-
we've officially closed.
no,
the
you
hearing.
Yeah,
haven't.
I have a motion on,
Yes,
that-
so we were just kind of clarifying what you're, okay, so all right. So,
open. But you might want to make clear, because you've been conversing. with-
Right.
Whether you're in open or closed deliberation.
Okay. all right, let's do some close deliberation and we will entertain the motion to approve. With conditions. And what are those conditions? Mr. Court?
so it's my understanding that the motion would be amended to add the condition that the applicant shall adhere to tree protection standards as required by City of Charlotte Urban Forestry.
Okay, that's one, and then other that they will not build in the,
I think the motion, the original motion included that
okay,
without objection from
from the
the
applicant.
legal people.
Okay. All right, so there's a motion to approve with a condition that the applicant shall adhere to the tree protection standards by urban forestry. Or words to that effect. I didn't get it down exactly. Is that okay?
And the first condition stated by Mr. Court.
Yeah, and for
Two
the,
conditions.
and for the conditions to mentioned in, okay, and for the green space. Space condition, okay. Okay. All right, do I hear a second?
Shay, second.
Thank you. All right, Mr. Williamson,
Williamson, yes.
Mr. Shea,
Shay, yes.
Ms. Sun, Mr. Court,
Court, yes.
Dryden, yes. So we have approved the variance with the conditions about tree forestry and about the green space, no buildable area, nothing built in those areas. Okay. All right. Now we need to look at finding of facts and conclusions of law, and Mr. Murray has provided us with his wording. I think number 11 on our sheet, the original is the applicant shall comply with that's the one about the urban forestry. So with tree protection under the urban forestry rules to maintain the existing heritage tree. So how do you want to reword number 11?
Could I make a
Yes.
suggestion?
Yes, please.
Oh,
Are we out?
Oh,
No.
do we need to come out?
Think he would.
All right, we need to come out of closed session and we'll open it up so Mr. Kinley can offer his suggestion.
so are you going to modify the staff's findings of facts and conclusions of law? Because there's quite a bit you would need to modify
Or just
to
go,
reflect an approval. So I would suggest you utilize the applicant's findings of facts and
Okay.
conclusions law and add your condition for the tree protection to his.
all right. Thank you, Mr. Kinley. All right, let's go back in the closed sessions board and let's do that.
Well, so number 13 becomes. Number 13 is the one where I think you want to add the verbiage.
Right. So number 13 needs to read that applicant. Number 13. Has agreed No, the applicant shall, sorry. Comply. All right, now where do we go from there? What's the verbiage there? Comply.
Jim, you have verbiage you wanna?
The verbiage of the motion, right? Yeah.
I was off looking at a different one. So the applicant,
Shall comply with,
I think the verbiage of that was included in the motion makes sense as well.
yeah, that's what it does. I just want to make sure we got it right. The applicant shall adhere to the tree protection standards set forth by urban forestry.
right, yeah, so I think you could delete the words has expressed a desire to and insert the applicant shall and it
In which,
Oh, well,
We're using their.
we're using theirs.
Murray's.
I mean, but he's looking at our number 13 just for the verbiage, but we're adding it to Mr. Murray's.
Right.
It would be
Not 13.
number 13. So it says there is a large 47 caliber existing here
Oh,
near the front of the plot. The applicant wish to preserve as part of the development lot. So we're taking out the wish part and we're putting in there. So I think number 13 on Mr. Murray's should read now. The applicant shall comply or adhere. I think I like adhere first.
Adhere.
Yeah. Adhere to tree protection standards.
John said, he said adhere to urban forestry standards.
Okay,
I'm sorry, tree save standards,
tree save,
tree protection standards.
tree protection. Okay.
tree protection. All right,
As-
applicant shall adhere to tree protection standards
As required by the city of Charlotte for
as
urban
required
forestry.
by tree forestry. Is that all right? Or by urban forestry?
I would also suggest that you add a number 6 to the conclusions of law that also states that condition.
Oh, yeah, we'll get, we haven't got to the conclusion of the law yet.
Okay.
Okay, all right, and then. Area outside the area. All right, where in yours, where in here does it say that they won't build in the buildable area? That's, I want that in this, in the finding of facts and conclusions of law also.
Is contained in conclusion of law number 5.
As a condition of approval of the variance, the applicants have agreed that the survey below shall operate as a site plan and that no buildings shall be placed other than those shown on the plan.
That's nice.
Okay, I like
Nice and
that.
clear, yeah.
Okay, and what was the other one that you wanted us to look at in conclusions of law number 4?
To add a number 6
Oh, number 6.
states the second condition.
Oh, okay. So number 6 would be the condition that says the applicant shall adhere to the tree safe protection standards as required by urban forestry.
Yes, I think we state as a condition of approval of the variance and then
Okay,
add the sentence from number 13.
okay, as a condition. Okay, did we get all that, people?
Make sure, for the minutes and for our findings and approval letter, I want to make sure I have the wording of 6 correct. The applicants shall adhere to the tree protection standards as required by urban forestry.
And
Is
I
that
would
what everybody else has?
include at the beginning of that as a condition of approval of the variance. And then can you state that sentence again?
As a condition of approval of the variance, the applicants shall adhere to the tree protection standards as required by urban forestry.
Right. And then that will be reflected in the number 13 on Mr. Murray's. And it wouldn't say as a condition there, it would just say the applicant shall adhere, correct? So we've changed number 13 to the applicant shall adhere. And then we've added a number 6 that says as a condition of approval, the applicant. Okay. Any other changes that you see?
I'd like to ask staff a question. Do I need to go out of?
Yeah, we need to come out of closed session and we'll open it up. You may go.
Okay.
And ask the
I
question.
I just want to point out number 15 and make sure everybody's comfortable with them referring to it as operating as a triangular lot. You know, it's got 2 streets on it, making 2 sides, and so I don't know. They're saying it operates as a triangular lot. If you guys are comfortable with this? I mean, it seems like a straightforward, it's not like all the triangular lots that they pointed to in the neighborhood don't have an intersection behind them. And so it's pretty much definitely not a triangular lot unless it's got one road that like curves on that one side. I mean, I get that it functions as one, but do we want, I mean, is it going to confuse things if we start referring to it as a triangular lot when it definitely
Why don't
has
you say
2
the
roads?
site Functions instead of operates.
Right. Well,
I don't know.
I mean, I think the distinguishing factor is like how zoning and it's interpreted by the UDO versus how it functions or operates. I don't know that there's a huge issue with that wording. I
okay.
do see what your concern is. But since it doesn't say that zoning treats it as a triangular lot, I think we
Okay.
are okay with leaving it as is.
All right.
Well, or we could just take it out altogether.
Say, or just remove it.
Just remove number 15 altogether. I mean,
Yeah, I'm good to remove it.
yes, ma'am.
I'm gonna sit your honor, if I may. Madam Chair.
You're so kind.
Part of the, I guess my question to the board would be, but does that finding of fact contribute to the peculiarity of the property?
I see what you mean.
Or why this might not be a hardship created by the property owner? So if it doesn't hurt anything to leave it in, I would recommend.
Yeah, I think it
leaving
does contribute to the peculiarity. I think 16 addresses it too, but I think having 15 in there helps reinforce that. And you know, I just wanted to bring it up because I didn't want it to be confusing and and it sounds like staff's comfortable, so.
Well, and it does say the UDO still treats the lot as a rectangular for purposes of applying setbacks. So that covers what you were saying, John. Okay. All right. Thank you. Ms. Sanchez Myers. Okay. Any other changes? Do I hear a motion to approve the finding of facts and conclusions of law as amended?
Court moved to approve findings of fact and the conclusions of the law as amended.
Do I hear a second?
Second.
Thank you, Ms. Sun. Okay, Mr. Williamson,
Williamson, yes.
Shay, yes.
Sun,
Sun.
Court,
Court, yes.
and Dryden, yes. So we have amended the finding of facts and conclusions of law. We voted to approve that as amended. All right. Flag that because I want to read this carefully. All right, thank you.
Right here, buddy.
Do you need to leave?
Yeah.
Okay, all right, a board, we're going to have a board change. Mr. Williamson has to duck out. And so Mr. Gary Young will be joining us as our fourth. Thank you, Mr. Williamson. Have a great day.
See you, buddy.
Okay,
5 minutes.
oh, I think we're good. All right, we're ready to, thank you, Mr. Murray. Thank you, sir. Appreciate it. All right, our next variance is for number 2025-00040 for a property located at 0 Queen City Drive. Oh, yes. All right, you want to take, do you need 5 minutes? Oh, okay, sorry. All right, thank you. Is there anyone here to speak, John, for or against this?
Staff is recommending against this.
Okay.
Oh, well, yeah, the applicants are.
Oh, okay, all right. Well, the applicants come forward and you may sit at the table and I will swear you in.
Yeah.
All right, thank you. Please state your name for the record and spell your last name for the court reporter, please.
John Carmichael, Carmichael.
Josh Glover, Glover.
Thomas Habapro, Haapapuro.
Okay, and gentlemen, do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can pull up another chair if you like. All right. Okay, John.
All right,
We're ready.
on this one, we do have an additional parcel number and address to add in on the agenda. It's reflected in the, on your findings, but not in the presentation or in the agenda. So the additional address is 6301 Tuckasegee Road. And the additional parcel number is 06125-107. And again, the findings of fact that Kamisha passed out show both of those. So this is a variance request 2025-00040 by Gray Star Development East LLC, represented by John Carmichael of Robinson Bradshaw, for a property located at the 6301 Tuckasegee. It doesn't really have an address on Queen City Drive, but 0 City Drive, I think, is what showed up in Polaris when you put in this parcel number. And then the other parcel again is the N1 ending in 107. They are seeking a variance from Article 5.3C, Table 5-2B, to eliminate the frontage build to zone requirement along the site's frontage of Queen City Drive. Here's Exhibit 1 is a vicinity map of the property. And this is out towards the airport past Billy Graham Parkway's interchange is on 85. So Queen City Drive is essentially functioning as a service, parallel service road to 85 along that stretch there, and ties in at Little Rock on the west side. This is a zoning map of the property. Again, it's 2 parcels, but one development site. It's currently zoned into C Ando, which is Neighborhood 2 zoning district, airport noise disclosure overlay district. That's a conditional zoning. This is a close-up aerial of the property. It's primarily wooded and vacant. There is or was a house up on Tuckasegee that was there before. And the variance request again is to eliminate that frontage built to zone requirement along the site's frontage of Queen City Drive. The site's zoning into C does require 0 to 20 foot build to zone along and other primary frontage. There is a footnote number 4 that will probably be referenced, so included it here. And it states when an existing Charlotte water easement or other utility easement overhead utility clearance requirements conflict with the build to zone requirement, a build to line shall be established at the edge of the easement or edge of the overhead utility clearance requirement closest build to zone. A build to zone shall not be required along frontages which abut a man-made or natural physical feature 35 feet in width or greater, such as but not limited to a railroad line, rapid transit line, gas pipeline, swim buffer, or a buffer related to post-construction stormwater requirements. And this does not include any stormwater control measure as required by the ordinance. The I guess, most applicable part of that footnote here to this discussion is a build-to zone shall not be required along frontages which abut man-made or natural physical feature 35 feet in width or greater, such as but not limited to those things that are listed after that.
This is the crux of the applicant's argument, yes?
Correct.
You explain in detail.
As to best of my ability, I will explain the case, yes. So again, I mentioned it's a conditional zoning plan. The condition, which was done through, city council approval, and the case number is RZP 2024-126. And that site plan shows a multifamily development with, in a multi-dwelling development scenario. So you have multiple multifamily buildings throughout the site. Queen City Drive is along the southern edge of this site plan. Tuckasegee Road is up here, and they would have a proposed street coming in from Tuckasegee, and then another street heading east-west. And there's an adjacent development that was previously approved. I don't remember exactly when it was, but it's zoned O2 CD that had a road coming in. And the objective is for them to tie into that with a cross access. And I think there's some conditions in the rezoning plan about that connectivity. And then they have a potential for a driveway out to Queen City Drive, which I think is going to be like an emergency access or used as the primary access if this connection doesn't happen. So that's the kind of the layout of the conditional zoning plan. You'll note that the conditional plan shows a tree save area along Queen City Drive with the multifamily buildings set further back from that road. So eliminating that tree save area to comply with the ordinance requirements would not be consistent with the approved conditional rezoning plan, would not be compliant with that conditional zoning plan. However, a conditional rezoning plan does not supersede or grant exception to requirements of the UDO. The approved rezoning plan acknowledges that the site would be developed compliant with the N2C zoning standards and Article 20 of the UDO. So note 1B, and I think in the findings I have a small correction that I'll get to whenever we get to that, but it's number 10. I think it says note number 2, it should be note B. But that note says that zoning district ordinance, the development and use of the site will be governed by the rezoning plan, these development standards and applicable provisions of the City of Charlotte's Unified Development Ordinance, the ordinance, unless the rezoning plan or these development standards establish more stringent standards. The regulations established under the ordinance for the N2C Neighborhood 2 zoning district shall govern the development and use of the site. So the conditional zoning plan acknowledged that they would be compliant with the N2C standards, and the purpose of the conditional zoning would be to potentially establish more stringent standards beyond what the ordinance requires. And then per footnote 4, which I referenced before, it talks about the abutting a man-made or natural feature 35 feet in width or greater, but not limited to the railroad lines, transit lines, gas pipelines, swim buffers, or buffers related to post-construction stormwater impacts or requirements. Tree save and tree areas are not listed in footnote 4, and Article 20 of the UDO and N2Z zoning do allow for applicants to have the flexibility in tree save requirements, including the option to buy out of tree save. And again, noting that on the conditional zoning plan, it showed a potential tree save, not required tree save. And then under environmental features, the development shall comply with the requirements of Article 20 of the ordinance. And that's Exhibit 5. Approved zoning plan details.
Sorry, John, one more time. You called Queen City Road the south side. That's not correct. This is the east side, isn't it?
No, it's the south.
It is south.
Yeah, 85 is running east-west. Queen City is parallel to that, running east-west.
85 is going.
It's 85 north and south, but it's in that area of town. It's running east-west.
16 is, that's right. 16.
Yes.
Yeah. Thank you.
And then exhibit number 5 here is the applicant's proposed site plan. Again, just modeling that after the approved rezoning plan and showing the tree save area along the frontage. And the next is the variance criteria. All 4 standards related to the variances shall have to be met in order for the board to grant a variance. And I'll give you a minute to look over the findings before I go through those.
Okay, John.
Okay. Unnecessary hardship does not result from the strict application of the ordinance. Again, compliance with the ordinance standards is acknowledged on the approved conditional zoning plan, RZP 2024-126. Applicant received and approved rezoning with conditional site plan that depicts tree safe area along the site's frontage of Queen City Drive. To comply with the frontage build to zone requirement, the tree save area would have to be removed to accommodate the placement of the buildings. Eliminating that tree save area would not comply with the requirements of the approved rezoning plan. However, the conditional rezoning plan does not supersede or grant exception to the UDO requirements.
Could you explain that to me? What does that mean? That it
So-
doesn't comply with, but so the rule is you gotta have tree save, right?
In the N2C zoning district,
Uh-huh.
and you are allowed to buy out or you're required to provide
Oh,
tree
okay.
save.
Okay,
And then the conditional rezoning plan basically acknowledges that they will comply with the UDO requirements for the development. But if they do have to comply and remove that tree save area, then that is different than what the approved rezoning plan shows. So they would probably have to go either back through city council or through some other process to modify that conditional zoning plan to match the ordinance requirements.
okay, thank you.
On the approved conditional zoning plan, sheet number 2, development standards, and that should read note 2B. Under general provisions, it states the development and use of the site will be governed by the rezoning plan and the development standards and applicable provisions of the City of Charlotte Unified Development Ordinance, unless the rezoning plan or these development standards establish more stringent standards. Regulations established under the ordinance for neighborhood 2 zoning district shall govern the development and use of the site. Exhibit 8, additional considerations. This is continued from before. Unnecessary hardship does not result from the strict application of the ordinance. Per footnote 4, build to zone is not required along the frontage that abuts a man-made or natural feature 35 feet in width or greater, but not limited to railroad, rapid transit line, gas pipeline, swim buffer, or buffer related to post-construction stormwater requirements. Again, trees and tree save areas are not listed in footnote 1, and Article 20 of the UDO and N2C zoning do allow for flexibility in tree save requirements, including the option to buy out of tree save areas. The conditional zoning plan, sheet 1, schematic site plan labels the tree save area along Queen City Drive as potential tree save. And on sheet 2, development standards, note 7, environmental features, note A, states that the development of the site shall comply with the requirements of Article 20 of the ordinance. Wow. And then number 12 in the findings, it says footnote 1, that should read footnote 4 in number 12.
Footnote 4.
Yeah. The hardship does not result from conditions that are peculiar to the property. The site layout and design could be reconfigured to accommodate the ordinance requirements. Hardship does result.
Wait,
from-
John,
Oh,
wait, before
sorry.
you go.
Because I want to be crystal, this is the most important slide in the entire deck, I'm assuming.
Right.
And I want to make sure we're crystal clear about this. The applicant is saying second bullet is part of the first bullet, and you're saying it is not. So you're ignoring trees and the tree save area that was conditionally approved in the rezoning. That's not cutting it in the UDO is what the argument is for planning.
The ordinance requires a build-to zone along the frontage.
0 to 20 unless there's something in the way.
Right.
Naturally in the way, like trees. But staff is saying trees don't count. Am I understanding this correctly?
That is correct.
Trees do. They are confused, the applicants then are confused. That the trees should have qualified for this, but somehow they got confused along the way.
I'm sure the applicants will speak more to it in their application. What they've stated in their application that they submitted to us was that there was discussions about that area during the rezoning process. And it was somehow not really entirely sure. I'm sure they could explain in more detail. It was understood to them that the tree save area would count as that natural or man-made feature of 35 feet in width. But that was during the rezoning plans discussion. But the rezoning plan does again acknowledge that they'll comply with the N2C standards, which require the build-to zone.
Okay.
The hardship does not result from conditions that are peculiar to the property. The site layout and design could be reconfigured to meet the ordinance requirements. We do understand that that might mean that they need to go back through to city council to modify the approved rezoning plan to match the ordinance requirements. Hardship does result from actions that were taken by the applicant because the approved rezoning plan acknowledges that the site will be developed compliant with the N2C standards and Article 20 of the UDO. It is the applicant's responsibility to ensure that the proposed site layout and design would meet the ordinance standards. N2C zoning and Article 20 of the UDO allow for a site design that is compliant with the ordinance. And the requested variance is not consistent with the spirit, purpose, and intent in the ordinance. And per Article 5.1C, N2C zoning district is intended for the development of multifamily dwellings, either as a standalone building or as components of a multi-dwelling development, and an urban environment with smaller setbacks and incorporation of build-to zones. So again, the intent of that zoning district is to have a build-to zone. And per Article 5.3C, building sited standards are intended to ensure development maintains compatibility with the intent of the applicable zoning district. And there's a sign on the property. And that concludes staff's presentation.
All right. John, just for my edification. The UDO says there needs, the tree, that trees are not considered whatever it is. They're not considered something that it's like because it doesn't say trees, it says railroad tracks and blah, 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 but trees. So the developer thought they could just not do the trees, or you want to?
I would probably defer the response to the applicants as to how they came to the conclusion that the tree and buffer area, the tree save area would be considered. Basically what it says is in footnote 4, it says a build-to zone shall not be required along frontages which abut a natural physical feature 35 feet in width or greater, such as, but not limited to, railroad line, rapid transit line, gas pipeline, swim buffer, or buffer related to post-construction stormwater ordinance.
Right. Okay.
So I think it's the such as, but not limited to part that creates a little bit of a gray area that the applicants got hung up on perhaps.
And the way I'm interpreting this is that they had a approved site plan that was a conditional site plan, and they went through a bunch of negotiations that had a big old tree save between them and the interstate. And the current zoning doesn't allow them to do that, and they want to do it the way they had it done before, and they're trying to make an argument to us to say why they should be able to do that the way they got it approved originally.
To do the tree save.
To do the tree save.
Not put the building on.
They want to keep the tree save like they agreed to way back when. The new zoning code doesn't allow them to do that. So they want to make an argument to us, and they're going to give us a lot of ways into that
Okay.
to keep the tree safe.
Okay. All right.
But I could be wrong. We'll see what they do.
Okay, Mr. Carmichael?
Thank you. Madam Chairwoman, members of the board, I'm John Carmichael, and I'm here on behalf of Greystar Development East LLC. With me this morning are Thomas Hapapuro of Design Resource Group. He's the land planner and landscape architect that worked on the site plans that we'll share. And this is Josh Glover with Greystar. John, just use the arrows to advance it.
Yeah.
Okay. So John's gone through a lot of this, but the site's located on the north side of Queen City Drive and on the south side of Tuckasegee Road. Here's Tuckasegee Road. It's just over 11.5 acres. ID5 is located to the south of the site, just south of Queen City Drive. Obviously, the site's outlined in green here. This is a zoomed in aerial. It helps a little bit. You can see Queen City Drive here, and then Interstate 85 here. And as you can see, the site is very heavily wooded or treed. So I'm gonna give it a little history as we understand it on the the trees that have been on the site. And these slides that I'm going to share with you were procured by Mr. Hapaparo from the Mecklenburg County Time Machine website. So as of 1938, there are not really many trees on the site. It looks like it's been farmed. As of 78, there's a gap between 38 and 78. I'm not sure why. Thomas can explain that, but as of 1978, it is very heavily treed, as you can see. And then as we move forward in 93, it was treed. This is Sheet Circle over here, which is just to the west of the site. And then 2002, same condition. As you might imagine, the next slide is current condition. And once again, it's heavily treed again. This is a slide that shows the distance of the southern boundary of the site to the northern edge of I-85. According to the Polaris measuring tool, it's just over 64 feet, 64.43 feet. So it's pretty close to the northern edge of I-85. And then these are Google Street Maps, the Google Street Map view on Queen City Drive right in front of the site. And that's the southbound traffic on I-85. You can see once again, it's very close. And then this is another Google Street View picture of Queen City Drive in front of the site. It's just a little to the west of the picture I showed to you previously. And you can see there are no natural or man-made physical barriers between the southern edge of the site and I-85 other than this chain link fence. Thomas, can you come up real quick? Thomas, just take your full name, your business address, education background, where you're employed, how long you've been doing it.
All right, my name is Thomas Hapaparo. I'm a senior principal at Design Resource Group, which is at 1100 Hawthorne Lane. And I've been with Design Resource Group since 2001.
And what do you do?
I'm a landscape architect, land planner.
And were you involved in the plans that we're going to share?
From the very outset.
Okay, and you're familiar with section 5.3C, table 5.2B of the UDO?
I am.
Okay, and as Mr. Kenley pointed out, this is the frontage build-to zone requirement, and it's Queen City Drive is an other primary street, is that right?
That is correct.
And the build-to zone is 0 to 20 feet from the setback?
That is correct.
Okay. And then this is the footnote 4 to table 5.3C, section 5.3C, table 5.2B. And were you aware of this provision when you prepared the original rezoning plan?
Absolutely. I was aware of the build to zones in general. So the new network streets that I'm providing internal to the site met those build to zones. We thought our understanding of the natural feature would include a tree. It seemed a natural interpretation of the ordinance to think that a tree safe area would quantify as a natural area. So that is why we had shown that particular frontage not meeting the build to zone, because we thought it was exempted due to natural feature status.
Okay. And we don't really have much argument in the facts that Mr. Kenley laid out here at all. It's really what Thomas thought this provision meant, how it would apply to the plan, and then going through the rezoning process, sort of what information that we were provided. But I will say that John Kenley's right. The conditional rezoning process does not grant legislative variances from the requirements of the code. And despite what the approved plan may say, it doesn't grant a variance. So to get a variance, we have to come to this board. So on October 15th, 2024, Greystar filed a conditional rezoning request for this site, requesting that it be rezoned to the N2C zoning district. And the purpose was to accommodate the development of a residential community that would be comprised of up to 306 non-income restricted but attainable multifamily dwelling units, and then amenities for the residents. So this is applicant's exhibit 13, and it's the original rezoning plan that we filed back on October 15, 2025. I'm gonna ask Thomas to briefly discuss that, but would like to ask you, Thomas, why did you want to use the N2C zoning district for the site?
Yeah, so it's a fairly constrained site with a fair number of obstacles to be dealt with. On the western side of the site, there's an existing Charlotte Water easement. This site had network street requirements that were challenging and took some of the area away. Also with the Charlotte Water easement, this site naturally,
There's
Yeah,
a sharp water easement here.
correct.
And there's a buffer here,
Correct.
and then you got the public road here.
Mhm.
Okay.
And so topographically, this site should have had two ponds. But because of that Charlotte water easement, we were prohibited from outletting to that direction, so we had to kind of aggregate our ponds into one location. So, and then we had additional items that we were negotiating for minimizing our impact to our neighbors as well. So there were multiple things that were kind of chewing away at the site. So this naturally is an N2B site. However, we knew that we weren't going to be able to do full tree preservation on site, that we would need some amount of relief from the tree ordinance to be able to use the mitigation options. In the ordinance, there's an all or nothing in N2. You can't get any relief until you go to C. So even though we were clearly planning on preserving trees and utilizing those trees to buffer the impacts of Queen City Drive, we knew that some amount of mitigation would be necessary to accommodate all the various site elements.
Okay, and we did discuss using the N2C zoning district with the planning staff prior to filing it at a pre-submittal meeting. And the planning staff wanted to consider it, and then they got back with us and said that they were comfortable with the N2C zoning district for the site. Planning did recommend approval of the rezoning request and the pre-hearing staff analysis. The analysis is issued by the planning staff prior to the public hearing, and in the post-hearing analysis and the final analysis. But I do want to be clear, we're going to go through some of the rezoning plans. We never were told by planning that we did not have to meet the frontage build-to zone requirement. I mean, I know John raised that as a possibility, but I'm not going to represent to you that planning staff said footnote 4 works here and you don't have to meet that requirement. That was never said to us. But Thomas was under that belief, and the rezoning plans that we submitted, the original, the one on December 16th that was submitted in response to staff comments. As you probably know, when you submit a conditional rezoning plan, it's sent to the various government departments, and you get comments back from those departments as to things they'd like to see and things that you're required to do under the code. So we submitted a revised plan on the 16th of 2024 in response to comments, a revised plan on January 13th, 2025 in response to additional comments, and then a revised plan on February 21st. And you can see that the rezoning plan really doesn't change that much, or doesn't change really at all with respect to the southern boundary of the site. And then this is the February 21, 2025 version that I just showed you. And then this is the final version, or the approved rezoning plan from March 17 of 2025. With respect to access, this is an access point. And as John was saying, the thought is, or the hope is, you could connect to this road here. But we have a provision on the rezoning plan that if you can't connect to this street by the issuance of the 155th certificate of occupancy for a residential dwelling unit, you then have to make a vehicular connection to Queen City Drive if it's approved by NCDOT. If it's not approved, then you have to do a fire access. I understand, Thomas, that NCDOT has communicated with you and it's been approved.
That is correct. NCD has approved the driveway location somewhere along this frontage.
So if that connection can't be made, essentially by the time that half the units are CO'd, then you'd have to make that connection there from Queen City Drive. But we went through the process, and this is not a criticism of the planning staff at all. It's just really how the process went, that we didn't receive any comment that we were not in compliance with the code because we failed to meet the build-to zone requirement along Queen City Drive. And that really just furthered Thomas's belief that his interpretation of the code was correct. So Thomas, can you identify this exhibit?
Absolutely. So after successful rezoning, we started vetting out some of the nuances of the UDO as we started to proceed towards construction documents. So this was the next step in that verification. I had submitted this to the city to determine. Essentially, my argument was this, like, hey, I know I don't have to meet frontage along this side. Is there anything special that I need to do to the architecture because I'm shielded from the street by this tree save that I showed in my rezoning. So that was the reason for reaching out on this, was to just confirm some architectural components.
Okay, and you were told that you needed to meet the
And
building.
it was at that time that it was discovered that the natural area does not include tree save.
Okay, and why are the trees, well, first of all, our variance request is to eliminate the build-to zone requirement along Queen City Drive. I would like to add that if you were inclined to grant the variance, it should, in our opinion, be conditioned on maintaining a tree save area along Queen City Drive that's a minimum of 35 feet in width. So it's consistent with footnote 4. So it'd have to meet the tree save requirements of the ordinance, would be at least 35 feet in width. Then you have a no build zone of 10 feet. You couldn't build anything closer than 10 feet to that tree save area. So that would be the applicant's request, once again, is to allow the site plan, or allow the development to proceed without pulling those buildings up to Queen City Drive and removing those trees. And Thomas, why are the trees important for the development in your view?
Yeah, so the trees are there. Largely why this is so important to us is that the adjacent roadway system is a fairly intense use. And we want to do as much as possible to minimize the impact of that use on our residents. So that's the real reason that there's, few things that do a good as job as mitigating various environmental issues as a naturally occurring tree stand, particularly one that's been there since at least the 50s. It's an established tree canopy. We would like to utilize that to minimize some of the negative impacts of being next to I-85.
And then just to show you what that would look like, if you met the build-to zone requirement, then that's how close it would be to I-85. Now, we recognize that I don't know if this condition would ever exist because the approved rezoning plan doesn't meet, the rezoning plan doesn't meet the requirements of the ordinance absent the variance. But this is basically a picture of how close that building, it really emphasizes the need for the trees in our view. That's what this does. It's the need for the trees to help screen the site and to buffer environmental impacts such as noise and fumes generated from I-85.
And John, if I could explain this a little bit further, what's going on here as well. So Queen City Drive is shown in its existing situation. There's also a widening that'll happen with the streets map. So there'll be additional pavement added here. And they'll have our 8-foot planting strip, 8-foot sidewalk. But note too that the power lines are there. So the trees that I'm going to put in are not going to be large maturing trees. They're going to be small crepe myrtles and things of that matter. So I'll have very little opportunity to replant after the fact to get any kind of separation distance between the I-85 and the frontage if I had to build it as per the zoning code currently exists.
So here again, we don't dispute the fact at all that the rezoning plan said it would meet the requirements of the ordinance, because you have to say that in your rezoning. Really, the issue is, footnote 4 and the belief that Thomas had that would apply to this site because trees, not trees that he would replant, but trees that have been there for decades qualify as a natural feature. And the footnote 4 does say such as, but not limited to. It's not, in other words, it's not an exclusive list of natural features. We did file an appeal of that determination, but it's been withdrawn. We're not seeking to set precedent here in terms of what the ordinance means. We're looking for just a site-specific solution here to the issue that Greystar has with respect to the site.
All right, can I add? All right,
Sure.
this is what you want to build?
No, we do not want
This
to
is
build
what the
that.
All right,
ordinance,
so it would be, your building would be farther back?
Yes, ma'am.
45 feet
Right.
minimum.
Be that. So this is what, if footnote 4 doesn't apply, and had we gone through N2C the whole way, then this would have been the condition, having the building 0 to 20 feet from the setback. Because the thought was that footnote 4 applied, the design team at Greystar desired to preserve existing trees on Queen City Drive and have the buildings further back. But once again, that doesn't meet the requirements of the code. Am I making it clear? I hope so.
I think I can clarify this. The city, the build to zone.
You talking to your microphone, sorry. It does make a difference.
Zone is a requirement by the city. The city thinks that buildings should be on the street. They should be right on the street. And I hate that. I hate that. But South Boulevard makes sense. If you're on the railroad, makes sense. But here, these guys don't want to put it on the building or on the street because they want to have a buffer area between 85 and Queens Road and, I'm sorry, Queens or
Queens Drive.
yeah, and then the
Queen
then
City
their
Drive.
building. So this is all because of this build to zone is a requirement from the city to put buildings right on the street. And these guys don't want to do that.
But I will,
It's all coming down.
there are certain zoning districts that do not require build to zone. The N2C zoning district is the multifamily district that does require build to zone. And in the intent statement, it's intended for urban environments where you would have, it would make sense to have your buildings up close to the road. So there's a bit of an issue with the applying this zoning district in an area that is not necessarily suited for it.
That's correct. So back in what John is, I think we got to understand it's like when you have urban districts. So when our city's a suburban city converting to urban, we have certain areas that are urban, which N2C makes sense when you put it N2C in a suburban area. And then staff says you now have these urban conditions you have to meet. We run now the developer being fair saying, hey, we thought we could do this, which would alleviate that. And staff saying, you don't get to alleviate that because again, you went to this urban district. So for example, if you went to a suburban district, we wouldn't be here.
Yeah, that's true.
But
Yeah.
I mean, my question is what's I'm gonna put it right on the road with a sidewalk. What is walkable from that sidewalk as far as the city is concerned about building right on the road? I mean, I can see if it's in a, like close to transit or close to something that you can walk to, but I'm looking at this site and I don't see any place to walk to.
Well, think of it as it's not walkable it's not walkable right now, but in the future it would be because like the other rezoning there, we would get sidewalk along it and we start building across the street. So for example, I tell everybody, I use the example, 485 didn't go all the way around the city, but at points we built incrementally and then we got an entire circle around our municipality. The same way with our sidewalk system. It's when we start seeing these things start to be rezoned and start to develop, then you start getting that network of sidewalks. And then where we're missing gaps, we as the city would then come in, fill those gaps in.
I understand that, but it seems counterintuitive to cut down trees just to put the building on the side of a road. I mean, if I was renting that apartment, I would much rather have trees behind my house that, multiple trees rather than, I mean, that's just a personal thing, rather than I look out my window and I see a single tree and a road.
I mean, I think we would say, we're not disagreeing with that, but then we would also say, as staff, I would have recommended, hey, you should rezone to a suburban district so that way you can have those trees and you're not being forced by a zoning district requirement. Because also the same road, I would say, I may not build a multifamily in the direct line of an airport with runways.
Right.
And so it's kind of like, you
Yeah.
got all these things that
Think about
start,
that too.
that start coming together. And at some point, you're like, hey, this, again, staff doesn't get the ability to say you can't develop something here because they went to a legislative rezoning process and now they got it. But at some point, we would say, hey, let's recommend to the applicant that they go to a district that doesn't have that requirement.
All right, now, the applicant, why did you tell me again why you wanted to change the zoning?
Well, first of all, we had to rezone it to allow the multifamily use, but you're asking why use the N2C as opposed to the N2B?
Which was my early statement. So N2C is the only zoning district up to that point that allows any kind of flexibility in on-site tree preservation. Everything else is full 15% preservation of trees. We knew that we needed some flexibility to accommodate all the different site elements. So because we started as an N2B zoning, realized that we couldn't meet all the tree save requirements with all the stuff that we were finding out about the site. So we went to a higher zoning class. However, I will say that the N2C has different parameters for smaller lot size, there's more incentives to N2C, but I didn't
basically you
use
did it so you
that.
could put more buildings in it.
I utilized it so that I could have some flexibility on the tree save.
Well, the tree save and more buildings, because if you had a lower, then you could do the tree save and have fewer buildings for people, but you wanted more buildings, so you did a trade-off. Don't cut the trees down, but I have more buildings, or I build fewer buildings and do the tree save. And now you're coming to us saying, but we really want to save the trees. It's okay. I mean, I understand, but it just seems counterintuitive to me. Okay, go ahead. You had a question?
Is there a payment in lieu option too? Yeah. Okay.
Yeah, there's payment.
There is.
All right, you may continue.
Mr. Glover's here. Josh, you want to add anything about the desire to maintain those trees and the importance of it?
I think y'all are they are.
The
Oh, I'm sorry. I heard you say that like 10 times and I still didn't do it. Do I need to repeat that?
is the red button, yeah, repeat.
Okay. I mean, you stated that well, John, but our intent was really to preserve that buffer in order to preserve quality of life and environmental impact considerations for the residents facing that, those southern units.
Well, that, here again, Miss Ma'am?
Mr. Carmichael, can you go back to the current plan that is approved at this moment for you?
This one?
So this is your current. Does possess the trees. That area on Queen City Drive, that's not your, that's the tree save area.
Right here?
Correct.
Yes, that's tree save.
So it's approved with the tree save area as it is.
Yeah, so the question is, where is that handoff? Where did the handoff miss? That's where I'm really
Yes.
confused, because it had to go, you guys applied for N2C, right?
Correct.
And that was stamped on the plans.
Right.
And it had to go through, you guys had to go through staff.
The entitlement services staff reviews the rezoning plans for zoning compliance. Entitlement services staff, so the staff that processes the rezonings through to city council, they're the ones who review zoning plans for or conditional zoning plans for zoning compliance. So it doesn't, like Solomon and I, our staff, we don't see
So think of it
those.
as land development. So think of it as rezoning plans are done at a 30,000 foot level. Once they come into land development, then we now start looking at all the fine details. So now it's sidewalks, fire, water and all those things. And then what happens is that's when staff will say, we'll go to the applicant and say, hey, you have a bus because this is what the interpretation. So even like I tell staff, so like I would tell all the entitlement service staff, if there is a clarification of the code, the applicants would need to come to the zoning administrator to clarify what that is. And then we would have given it a written interpretation or have a discussion about, and a lot of times I try to have discussions with to say, hey, this is what the intent of the code is. This is what we're looking for. But again, since John and I weren't part of that process for the rezoning, I don't know where that discussion landed.
So is it fair to say that the tree save and the N2C zoning, that's a 30,000 foot detail?
That is correct, because as you guys, if you guys don't know, most of the time with rezonings are kind of shown, but staff all the time is adjusting things for because again, something wasn't aware of, things happen because again, it's kind of like if we fully engineered plans during rezoning processes, developers would get killed because again, they would be spending $100,000 and then council would say no. And that's not the way the city wants to operate.
Solomon, can you please let us know what would be considered a natural physical feature 35 feet in width or greater?
So typically natural physical features would be something like we're looking at, would it be a creek, stream, road, something there, like for example, where some of the sites we've seen where someone had a conservation easement, things that would prevent them. So like when they mentioned like the like a, natural feature. So that's what we kind of look at. Because here's the thing, tree safe can be adjusted. There is nothing that says tree safe has to go, because they can, as part of working with urban forestry, they can put tree safe anywhere on the site as long as it can comply. And I know when they're talking about the 15%, it's yes, in the N2B, the ordinance just says, hey, you have to show us 15% on the site. They would be able to put that 15% anywhere as long as it's met urban forestry standards and Article
But they
20.
chose to put it near the road, which is,
And it does say potential. So
Yeah.
there is the approved rezoning plan says potential. It doesn't say that's where it has to be.
And that's correct. And John is correct. And in the past for conditional rezonings, when it sets potential, staff has always said that's one area, because again, staff has been hammered many times talking about site plan shown is one of 1,000 ways it can be built. And we've gone through that. And I guess to say, as someone who's done the administrative process in Article 37 for conditional plans, I've had to defend developers against citizens. I've also had to tell citizens developers have done things because again, when those things are moving around and they're in this box, there are some things being fair to the designer that, hey, we just didn't realize, or a regulatory entity says, hey, you need to do this, and just wasn't, the rezoning just doesn't show that.
My apologies for the redundancy, but it's 15% if it's a N2B requirement. What's the requirement for N2C?
I still believe it's 15%, but as Thomas, Mr. Harper Pearl has stated, that they get more options. So there's a buyout option. There are things that they can do that allow them that. Whereas you don't have like in the other one districts, you don't have a buyout option. It's, you just got to build it, or not build it. You've got to save this 50% of tree save.
Do you have other plans? Do you have plans where you can potentially put it elsewhere? Or is that your only option?
This
for
is
a
the
tree
this
save area?
approved plan, and they wanted to have trees up along the road. So they don't really want to pull the buildings up to the street, and that wouldn't meet the intent of the rezoning plan in any event. But I think Thomas would say that they under footnote 4, they knew they would have to have something 35 trees 35 feet in width along Queen City Drive to meet that footnote. Here again, he was told later that footnote didn't apply, but I guess in some really he read the footnote and it said natural features. You have existing stand of mature trees, not trees that would be replanted subsequent, not trees that would be planted after the development. And Thomas thought that was a natural feature within the meaning of footnote 4. It says such as not limited to. Understand that Mr. Fortune, Mr. Kenley disagree with that, and we respect that, but that was his reading. And then going through the rezoning process, there was never a comment that the build to zone needed to be met. Once again, that's not a criticism of anybody, it's just what happened. And so that furthered his belief that his interpretation of footnote 4 was correct. And so where we are now is we've got, as they've said, is we've got a rezoning plan that doesn't meet the requirements of N2C. And we're asking for a variance given the circumstances that brought us here. I mean, I think that's kind of the summary.
And if you don't get the variance, you have to start all over again.
That would be, yeah, you'd have to go back and do rezone, I guess, to N2B. I don't know that we could move the building. I don't think they really want to, even if they could, they wouldn't want to move the buildings up to the street. I think for obvious reasons, but they would need to go rezone it to N2B, as I understand it.
Well, even if you could move the buildings forward, you can, of course. If you did, this plan would not be approved, correct?
Well, I don't know that they would approve it because it doesn't meet the intent of the rezoning plan. Yeah, yeah. And so, look, I understand we're kind of in a crack here, but I do think it's understandable how we got here.
But you're not making, I guess, what Solomon said earlier makes complete sense to me. You're not making the argument that I heard, though, that it's not up to John and Solomon's team to catch this. It's the team that reviews this before you get to when you get into rezoning.
Yeah, we're not saying John and Solomon should have found this at all. And here again, we're not criticizing the folks that did review it. We're just telling you what happened. That going through the rezoning process, there was never a comment that didn't meet the ordinance.
That's important to us as a board.
Right.
I think it's under, I just want to understand how this happened
Right.
and these guys catch it, like Solomon was saying, 10,000 feet below, that's where you're gonna start running into money and details and so forth. You didn't get there. You had to get to 30,000 feet at rezoning. And no one caught it from that team that should have caught it. Is that correct?
Yeah, I mean, it somewhat comes down to interpretation, like, because my interpretation was that that might have been theirs as well. I don't know. We always been telegraphing clearly that we were doing something else for the frontage component of this Queen City Drive. So what?
But
what
that
is-
doesn't excuse that team from knowing what the ordinance is supposed to say and what you're supposed to do, and at least to bring it to your attention.
I think we need to be careful about the title service team because remember, they are doing numerous rezonings throughout the year. And they are also getting hammered by staff, council, everybody, citizens. And so sometimes, again, if it was an interpretation, again, staff sometimes as part of it, it's the designers to go talk to the zoning administrator, not necessarily relying on them. Because again, it's this whole process of, because again, if I tell you guys how much they're going through when they're reviewing plans, every time it's this long. And then there's also this part of, hey, was there negotiations with the neighbors that we weren't aware of? That now we've got to go and explain to a citizen that we negotiate that, hey, the design team negotiated something that can't be done by the code. Again, so it's kind of like, so there's all these wheels of play when you're going through a legislative process for conditional rezonings.
And honestly, I mean, to add to that, I mean, I think how we got here honestly is a moot point as much as the fact that we are here. It's a matter of how do we either rectify what the request is or act in accordance to what the city is recommending.
Right. And here again, I want to be absolutely clear about this. No one here is criticizing anybody with the planning staff. Okay. I've been doing this for 25 years and have nothing, these guys know this, nothing but respect for them. And it wasn't discussed during the rezoning process. That's my only point. That issue was never discussed by us with the planning staff or the planning staff with us. And Thomas thought that footnote 4 applied and it was never discussed. So he continued to think that. There's no aspersions towards anybody here. It's just sometimes that happens.
Right.
And we're looking for a site specific solution to that. And, we think kind of the hardship is that on them is that they would have to comply. Well, really, they'd have to rezone the property. That's part of the hardship. And then the location where the site's located, you need some buffering from Interstate 85. That's really the hardship. And, was it caused by, it results from conditions that are peculiar, really results from the process that was involved. And then the site's location 64.5 feet from the northern edge of I-85. And the results from, I think it was and reasonable minds can disagree, but I think it was a fairly reasonable interpretation of that footnote 4. I know this isn't an appeal, but that's really how this precipitated itself. That and the fact that, it wasn't brought up during the process. And, we think it does meet the spirit and intent of the ordinance in general because it's going to provide attainable housing. That's a goal of the UDO. And it's also going to provide, if the variance is granted, provide some environmental protection for the residents from I-85. I mean, that's really it in summary. Is there anything I need to add?
And that I am meeting the build to zones on the new street internally, right? So the street that's quieter, more residential, that street has absolutely got the buildings pulled up to the front to meet the intent of that N2C ordinance. It was just that the Queen City side was pulled back from for buffer desires.
Thank you very much. Anything else? Any other questions on the board or Mr. Carmichael or his team?
Just for clarity's sake, for staff, staff is basically stating, no, you need to put this building against the street per the UDO code.
I guess that is correct, that you have to come up with code.
Okay.
All right. Thank you, gentlemen. We're going to take 5 minutes before we reconvene.
Myself.
Madam Chair, Madam Chair.
So that's. Yes. But message.
Yeah, you're right.
Yeah, the other version's fine. It's a subdivision house.
All right, thank you for your patience. The board will now go into some deliberations about this rezoning. Thoughts from anyone?
So I think one of the things that kind of helps me through a couple of the hardships is the way the applicant has defined the hardship. And so and we talked about whether they do a lot of units or fewer units and whether it's one zoning category or the other category. But how they've defined their hardship is that they have a rezoning and that an approval, and if they were to have to redo that, that would be disruptive to their schedules. There would be delays in their schedules in being able to deliver this development. And so as we look at number 3, is that an action? Are there actions that they took that created that hardship? And I would say no, that they acted in good faith and obtained a rezoning by staff and did not. There were no surveying mistakes or anything like that. There was a interpretation or a differing of interpretation there, so that their hardship does not result from their actions. And then when I go to number 2, the hardship from conditions peculiar to the property, the size, shape, and topography are not peculiar. But I agree that the location, and I think they did a good job of demonstrating that the particular location in this being a walkable street with the interstate there and the highway there, and their ability to market a product that's on the road like that. It does seem like in this area there are streets that could be zoned in this category that would require and be appropriate for a minimum build to line or but because it fronts right there, the location's right there on the interstate, that is a peculiarity that is for this property in particular.
Okay, thank you. Ms. Any thoughts?
Yeah, I understand there's been the unfortunate misinterpretation of the code. However, I think it's the developer and the designer's responsibility to confirm with the zoning staff beforehand.
Okay. Mr. Young, thoughts?
Yes, I disagree with that first assessment. I think the code is what it is. I think our side of staff did their due diligence in identifying the misrepresentation of the zoning and the plan as it is. There is another facet to go into B, but as I understand, that will go against the money-making plans of this entity. It is a feasible way to get it done, but it's not feasible in terms of the allotted capacity they're looking for from folks that live there. In a nutshell, I agree with staff's decision not to grant the variance.
Mr. Shea?
I would say that I completely agree with Hamilton that there are peculiarities to the site. I also believe that they did some due diligence, but I'm also in agreement that if I'm putting together a multi-million-dollar project, I want to be damn sure that my site plan is approvable, and that falls on the land plan. And I think Gary's right. That should be something that should be approved, an email, something signed that says this is good to go. So the only thing that gives me pause here is that when we asked Solomon about 30,000 foot level and the 10-foot, 10,000 level foot level view of this. When you see that tree save and the build-to zone is not being applied and it's not caught in that first initial group and the rezoning group, not Solomon's staff, but the rezoning team that looks at this, that's the only thing that gives me pause. Is I got the impression that should have been caught. There is a line there where you can't catch everything, and you know the Solomon's correct. You just, if you ask for all these details from all the teams, there's 14 or 16 teams that look at these things, and you look for all those details, you'd be there forever and nothing would ever get developed. So I'm still kind of in a quandary here.
I would add that there is a solution. I would advise Greystar to lobby NCDOT or federal DOT to build a wall such as what you have on I-85 and Beatties Ford Road, as of what you have on I-77 and many numerous neighborhoods. There is a solution that is viable. It might cost money. It might incur expenditures that they did not plan to incur, but at the end of the day, to follow the code as is, there are solutions.
Well, then they can just rezone.
That's why I say that's one of the solutions.
The only thing I'd add to that conversation about whether it should have been caught at the very beginning, and looking at this from a 30,000 foot view, if you look at this and you're a planner and you're thinking about what would be the better design and what would be appropriate on this site, it seems logical, unless you're digging into the complexities of the code, to think that the better buffer would, from a giant interstate, there must be provisions in the code that would apply to that, and that surely there's no provision in the code that would force them to put their buildings right up on an interstate. So that is just me. That's not that's just a speculation on the way a designer or planner might be thinking that is employed by the city and looking at a rezoning. They might be looking at this and thinking, there's no red flag that, to me, when I see a giant tree save area buffering from an interstate, there's no red flag to me that says that doesn't make common sense. So.
The term potential is important too. I believe in those plans, the term potential was used for that tree save area. So when we're, looking at it from a hypothetical standpoint, from that 30,000 POV, they could have been taken into consideration once it got to that 10,000 view level, that potential would be something that's secured. So they could have just took that potential as, well, we can move it around. So again, but that's the moot point to where we are at this moment.
Well, for me, it comes down to the actual site of this. I mean, I know the UDO says they're encouraging right on the street development. But in this particular entrance, there is a street, but then the next, within 50 feet, there's an interstate. It is a peculiar hardship for the property because it does pretty much abut an interstate.
But staff is saying
That it's
should have been N2B, and
right,
this would be a problem.
and that would be a problem, correct?
Having peculiar knowledge of this area, having run for city council of this district, and actually having drove on Sheets Creek last week, you have to say that slow. I have no qualms with the code being followed.
Okay.
I think it would be fine, particularly looking at the future development that will occur.
Okay, thank you. All right. Do I hear a motion to deny or uphold this this appeal?
So motion to deny.
All right, excuse me,
Can we clarify for the record, it's a variance,
It's not an appeal.
not an appeal?
of the variance, I'm sorry. All right, so Ms. Sun makes a motion to uphold the staff's denial of this variance. Do I hear a second?
I second.
Sorry, so just for clarification, staff is just either recommending approval or recommending denial. So just want to
So
clarify
what's
for
the
the
verbiage
record.
that we need to
that-
use? Then she makes a motion to.
Yes, you're going to
deny
either
the variance.
approve the variance or you're going to deny the variance.
Okay.
Yeah.
So Ms. Sun is,
Deny the variance.
Ms. Sun made the motion to deny the variance. And
Young
Ms.
seconds.
And Mr. Young seconded. Okay. Mr. Young,
Young, no.
Oh,
yes to
Oh, well,
deny.
yeah, Young, yes to denying the variance.
Okay, Mr. Shea,
pass for the moment.
all right. Mr. Court,
Court, no.
okay. Ms. Sun,
Some deny.
Yes.
okay. Dryden, I'm going to vote no.
So question, my counterpart holding off on,
No to deny the variance.
right, my counterpart holding off saying at the moment. Is that a no or is that you abstain at the
Ms.
moment?
Sun made the motion to deny the variance, so that would be a yes to deny the
No, I
variance.
was talking about my counterpart, to my
Oh,
direct
okay.
left. He abstains.
We can't abstain.
That's what I was asking to
Oh, no.
clarify.
He has to think about it, but yeah, he has to vote.
So yes, 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 sorry, yes, yes, 3 yeses and a no right now.
No, 2 noes and 2 yeses.
2 noes and 2 yeses.
Yeah.
So you're in,
I want to approve the
So
variance.
she's saying no.
you will approve that.
So I said no, because the motion was to deny the motion was to approve the variance.
The motion was to deny.
To deny it, right. So I am voting no, I do not want to deny it. I want to approve it. And Mr. Port wants to do the same. He wants to approve it. And then Ms. Sun and Mr. Young say, no, yes, they want to deny it. So you have to say, yes, I want to deny, or no, I want to approve.
Those are my two choices.
Those are only two choices. Just don't look at Solomon.
I will vote no.
All right,
And for
Ms.
clarification, that's no to the
No
motion to
people's
deny.
motion.
So he wants to grant the
no to the
variance.
motion to deny. So the recommendation to deny the variance is approved.
The
No.
motion
No,
to deny the
the
variance-
motion to grant the variance is approved.
The, the motion to deny.
Right, right,
failed. There you
right.
go.
So you're
Thank
gonna have
you.
to
The
make a
motion
motion to
failed.
grant
Okay.
it.
The motion to deny the variance failed.
Correct.
Okay.
Correct.
Yes, correct.
Yeah. It's funny, talk about drawing a line in the sand.
All right. So do I hear a new motion?
Court moves to approve the variance. Are there any conditions?
No.
The applicant offered a condition. I don't know what it is by stated fact, so we probably need to get with that from the applicant.
Yes.
All right.
Well, we need to go into open session.
Yeah, we have to reopen if he's gonna talk. Yes, sir.
The condition that we would proffer would be that the applicant maintain a tree save area along the site's frontage on Queen City Drive with a minimum width of 35 feet. And it would have to be at least 35 feet plus the 10 feet because you've got a no build to zone, correct, Thomas? The only exception with that would be you could have a access drive. I guess the word's perpendicular into the site. Other than that, it would be the tree save. Now, there is a Charlotte water easement here that the tree save would not be in the water easement because they would clear those. But it'd be the tree save area, a minimum of 35 feet in width, plus the 10-foot no build. Meet the standards of the ordinance, really. That's the ordinance standards, 35 plus the 10. Okay. And then we'd have an access drive somewhere through the site, through the tree save, I mean.
Okay. So Mr. Court has made a motion to
Approve the variance.
approve the variance with the condition that they provide a 25-foot tree save plus
35 foot.
35 plus a 10-foot no build and a small access drive.
Well, I would say, the condition is that the applicant will maintain a 35-foot minimum tree save zone, which with an additional 10-foot no build zone,
Okay.
with the exception of required access drives and utility easements.
Okay. All right.
I'll second that.
So the applicant will maintain 35-foot minimum tree save with an additional 10-foot no build zone with the exception of an access drive and utility
I would just say required access drives,
except
the exception of city required access drives.
Okay. Okay. All right. Yes, yes.
I would recommend, yes,
Yeah, we'll have to, yeah.
And
I would recommend that we have the applicant draft proposed findings and bring those back for approval at the next meeting.
Okay.
Do we need to resolve my motion?
Yes, you still need to take a vote.
Yeah, we will. We're taking a vote to, approve, well, yes,
Well, if we're changing the findings of fact and conclusions of law.
That would be a separate motion.
right. This motion is just to approve.
Okay, yeah, right, you're right.
The
You're right.
court-
To approve the variance
Right.
with that condition.
With that condition.
Right.
And Mr. Shea has seconded. Okay, so Mr. Young,
Young, no.
Mr. Shea,
Say yes.
Mr. Miss Sun,
Oh, no.
Mr. Court,
Court, yes.
Dryden, yes. So the variance is approved. And we're going to request that Mr. Carmichael return next month with an amended finding of facts and conclusions of law for us to vote on. Thank you very much.
Is that a wrap?
Got to do minutes and then it's a wrap. Everybody had a chance to look at the minutes.
Make a motion to approve.
Okay, Mr. Shea makes a motion to, oh,
Court, second.
okay, Mr. Young,
Yeah. Yes.
okay, Mr. Sun,
Then yes.
Mr. Shea,
Going back and forth and confusing me here, girl.
I know, you may,
Yes.
yes, thank you.
Court, yes.
And Dryden, yes, so the minutes from the August 26, 2025 meeting are approved. Thank you very much. This meeting is now adjourned.
As a reminder, next month's meeting is a week earlier. It's on the schedule for November 18th. It's the Tuesday, but it's just 1 week earlier to accommodate for the Thanksgiving holiday. Next month's meeting, yes.
How about, no, next month is October.
Oh, sorry. I'm getting ahead of myself. I'm sorry.
I'm confused to know.
I think we're all ready for lunch.